Recording now. Okay. Welcome to a meeting of the California Paraprofessional Program Working Group. Justice Petra, would you like me to begin by taking roll?
Sure, and yeah, California Paraprofessional Program Working Group is a mouthful for first thing Monday morning. So why don't you go ahead and take roll, and then we'll take it from there.
Okay. Bashan?
Present.
Brynelson?
Present.
Helmuth?
Here.
Fleischman?
Here.
Hamilton?
Present.
Judge Harper?
Here.
Hartston?
Here.
Kirkmeyer?
Here.
McRae?
Here.
Olvera?
Here.
Justice Petru?
Here.
Robinson?
Here.
Judge Rubin?
Here.
Shining?
Here.
Sarouche?
Here.
Spiro?
Here.
Torres Ambriz? Wiley?
Here.
I'm sorry, Judge Wiley, and Judge Yu.
I'm here, thanks, and good morning.
Thank you. And it looks like we have a number of attendees,
Right.
44 at this
So
point.
what we're going to do is I'm going to give a couple of very, very brief introductory remarks. And then I'm going to ask Leah, I'm trying to look at too many screens at once here, as you can probably tell from the fact that I'm not speaking super coherently. Okay, I'm going to stop trying to do multiple things like looking at the next thing simultaneously while I'm speaking. I'm going to give some very, very brief remarks. I'm going to ask Leah to give an overview that I'll explain in a moment. Then we'll see where we are with the attendees and how many people wish to be heard and make some decisions about how we're moving forward this morning and this afternoon. So first of all, nice seeing everyone this morning. Thank you again for taking more of your precious time on this project. It's appreciated by everyone. I'm not going to spend much time. As always, we have a very ambitious and full agenda. I will just give you a slight preview to expect a survey coming to all of you regarding the name. You know, we've had discussions off and on about how no one seems to be very enamored of paraprofessional, and I'll put myself at the top of that list. And so Lee and I spoke with someone who is actually a naming expert. That's what she does for her living, which is a pretty cool job. And she gave us an initial long list of thoughts that have been winnowed down a little bit. And we're just going to send around a preliminary survey to get people's gut reactions. And we have some questions related to why you like certain things or don't like certain things that would be helpful to get your input on. So then we can send that information back to her and she can come back to us with something that is more focused. So I wanted to mention that that is coming. I also wanted to mention that at least one person said that he had not been receiving the notices from the state bar of when our agendas are up and when we post things. If that is the case, please circle with Linda and circle with whoever your IT person is. You should be receiving notifications. And if you're not, there's some disconnect happening with the systems. So if you, for example, did not receive the notification last week about the memorandum regarding the rules, then there's an issue there that we need to sort out because I don't want anyone missing anything. Speaking of rules, as I believe was said in Linda's email, we are not voting on that. It was an incredible amount of work and a great preliminary review. And we circulated it now for discussion and thought, not for voting. There are a number of things we would like to vote on today because the various subject matter subcommittees have been very busy, but we're not voting on rules. So I don't want anyone to think that we are doing that today. Last but not least, Lee and I had an opportunity to speak with State Bar leadership regarding timing and progress and all the rest of it. You know, I've had conversations with some of you about what is the pacing here? Why are we all working so hard? Can we slow this down? What makes sense? Which end is up? So along those lines, I wanted to try to have a better understanding for myself about why are we moving this quickly, other than obviously the need to maintain momentum. And as difficult as it is to put in this kind of a serious commitment, it's harder to do for a long time. If someone tells you you need to put in this kind of commitment for 9 months, okay. For 2 years, I don't know. I don't know that I would have signed on. So, there's other factors out there, but I needed to get a better understanding of the landscape. And rather than putting that at the end of the meeting today, I thought we would be better off hearing that at the beginning so that we understand what is happening moving forward. Also, because I think we have pretty much everyone on the call right now, and we're going to lose various people at various parts of the day. So Lee, if I could please turn it over to you for that.
Sure. Linda, could you share the PowerPoint again? We're going to move to the timeline. Can you advance the slide? Okay. So starting with today's meeting, we have, as Justice Petru said, a very ambitious agenda for today. We will, at the conclusion of today's meeting, cross my fingers, have moved through virtually all of the decisions around practice areas. There may be some follow-up work that's needed, particularly with respect to the in-court representation question. But in general, I think it's fair to say that after today, we will have wrapped up the practice area component of the development of the program, as well as taken an initial pass at draft rules of paraprofessional conduct. In May, we have a specially set meeting around the question of fee caps in particular. And that was specially set and designed to kind of model the approach we took around the in-court representation, because it's a question that has come up in many different subcommittees, and we think it's appropriate for a full working group discussion and vote. And if we don't have time at the end of the meeting, I will just give you all a heads up to say that I'll be sending out an email to ask you what kinds of information you would want to support your decision-making around the question of regulation of fees, and who you might like to hear from at that May meeting. In June, you will be asked to vote on the rules of paraprofessional conduct. Again, vetting them today, giving feedback to the regulation subcommittee and the staff team that has been doing the drafting. They will revise accordingly and bring back a proposal for a vote in June. You're also going to have the opportunity to consider state bar rule and California rule of court changes that will be needed to establish the program. And my wording here is somewhat careful. We are going to hear from Brady Dewar with the Office of General Counsel first up in the agenda to give all of you an overview of the plan for addressing the pretty significant scope of work that includes development of state bar rules and draft California rules of court, as well as the identification of statutory changes needed to establish the program. So you are not going to see draft language in June, but you will see key policy issues being brought forward for your input that will again form the development of the rules themselves as they are slated to go out for public comment later this year. You're also going to receive a revised recommendation from the licensing subcommittee in June. This is related to who is eligible to pursue a paraprofessional license. You should get recommendations on proactive regulation, as well as the governance structure and the licensee name. We will have issued that survey, analyzed the results, met with the expert, and hopefully have the opportunity to vote on a name in June. You can advance the slide. In July, another specially set meeting. I don't think this one has yet been scheduled, but here we want to focus on the program evaluation. Again, questions around how we will evaluate the program have come up in many different subcommittees. We want to address that as a full working group, as well as the type of public education and marketing that we would do to both educate the public about the availability of this new licensee and ensure that an appropriate knowledge base exists so the public can be protected from bad actors. Then in our August meeting, you will, prior to the August meeting, and this one, Linda and I will commit to getting to you several weeks in advance, you will have a draft of the final report from the working group. and corresponding recommendations. And so we intend to use the August meeting simply to review the draft and finalize the report. And then you see the report and recommendations going to the Board of Trustees at its September meeting. And here's where things kind of, they're somewhat in flux, but I'm gonna talk a little bit about some of the dynamics here. So as you see on the screen, a somewhat bifurcated process, with the board receiving the full report from this working group in September, and the board issuing for a 60-day public comment period the report and recommendations, as well as the draft rules of paraprofessional conduct. Then you see at the board's November meeting on this slide that we have a separate issuance for public comment of the rules of court and the state bar rules that are also needed to stand up the program. What you don't see here is issuing proposed statutory changes for public comment. And that, of course, is because it is not within either the state bars or the Supreme Court's purview to implement statutory changes. So while the report will include the identify statutory changes that are needed, we do not contemplate sending those changes out for public comment per se at this time. So you see here a bifurcated structure with the rules of paraprofessional conduct going on in September and the other rules going out for public comment in November. You also see then one additional meeting of the working group in December or January of 2022 to review the results of public comment and make any modifications in response to that public comment that you all deem are warranted. Now, the way this schedule would work, the only public comment that will be received back and analyzed would be the public comment related to the rules of paraprofessional conduct, not public comment related to the items issued in November. And you see my little asterisk here at the bottom of this slide, that the particular timing of when these various rules would be issued for public comment is in flux. And right before this meeting, I think it's fair to say that this is modified somewhat, meaning all three of the rules that you see on the screen would be issued for public comment in September, as opposed to a bifurcated approach. And when we go to the next slide, I'll be able to explain a little bit more why. So this schedule contemplates, I think we're missing one row here, Linda, that the working group would reconvene in December or January prior to the Board of Trustees January meeting. The board would then receive back the public comment on the rules plus any revisions that the working group recommended, and would, subsequent to its January meeting, submit a full proposal to the Supreme Court. And the proposal to the Supreme Court, we would basically be seeking the Supreme Court's conditional approval of the program. Obviously, the legislature needs to act, and we're all clear on that. But it is important that the Supreme Court give its initial approval. Yes, go forward, pursue legislative authority to implement. And yes, we're generally comfortable with the design of the program as articulated by the State Bar. And one of the challenges with that bifurcated issuance for public comment, September, November, things coming back at different times and being in different stages, is that if we have things going out for public comment in November, they will not be a full package, sort of a done deal package will not be available to submit to the court in February. As well, the public, who is going to, I think, be very interested in all three sets of rules, I think may be somewhat confused by rules being on multiple tracks. And so I think the decision is it's really important that all three sets of rules go out at the same time, that public comment on all three sets is considered at the same time, and changes are made holistically and comprehensively to the full set of enabling rules that will allow us to establish the program. So January, the board or State Bar would submit this proposal to the Supreme Court. We could expect to hear back from the court in either February or March. assuming the court does authorize us to pursue this further with the legislature, the state bar would then submit a proposal to the legislature in March. And that proposal, again, would include the program design, rules of professional conduct, state bar rules, proposed rules of court, and of course, requested statutory changes. So all of that needs to be submitted no later than March, really ideally for the legislative cycle. It would be even earlier in February, but we think we can get it done in March. And so between March and September, the legislature is vetting, seeking stakeholder feedback, public input, doing their own due diligence on the program that has been submitted by the bar. I'm sure there will be a lot of questions back and forth between the bar and the legislature regarding the program in those months. And one of the questions that we've had on the staff side is, well, what should we be doing, if anything, during that legislative contemplation period to get ready to implement the program? Because if the legislature does approve the program, it would be authorized to be established presumably January 1 of 2023. And we'd want to be able to launch the pilot phase shortly thereafter. So between March and December, as you can see on the slide without a lot of detail, there are a number of activities that the State Bar Executive Director has identified as being acceptable to do during a period of some uncertainty. And so those really involve the curriculum development, the exam development, working with the community colleges, just building the infrastructure so that January 1, we will be able to open up the doors and say, is anybody interested in being a paraprofessional? We're ready for you to start your training. So I apologize, the slides don't exactly match what I'm saying, because really before this meeting, I really clarified that we do need to issue all 3 sets of rules in September. So going back to the comments around, the pacing and why are we working this hard, I think you can see that it's a very condensed schedule. And the legislative process is the legislative process. So there's a pretty significant period of time there where we're done with our work. We've submitted the proposal and it's moved on to the legislature. But in order to meet that March deadline, we really do need to have all of this done by September, out for public comment. And again, you could expect to be asked to attend one additional meeting in either December or January to review that public comment and make recommend modifications as appropriate. So I'll pause there and see if there are any questions. Carolyn.
Could you put together something that lists the public comment period? And also, I think you said that some things will not be, there's no public comment on certain things. I would like a list of those in writing. And then finally, there's nothing in here that I see with regard to sending and getting the comments of the State Bar's Committee on Professional Responsibility and Conduct. And I think we have enough time, it sounds like, to get that done. So will this proposal be submitted to COPREC?
Okay, so I think the thing I said that the State Bar typically does not put proposed statutory changes out for public comment, because it is neither, under the purview of the State Bar or the Supreme Court to authorize statutory changes. It may be in this instance that we at some point put proposed statutory changes out for public comment, not because we have the ability to effectuate the changes, but simply to inform the development of the proposal that would go to the legislature. But that's what I referenced, Carolyn. That would be the only thing. There is at this juncture nothing contemplated regarding a referral to COPREC. I don't know, Randy or Andrew, if you have an immediate reaction to that. These are not attorney rules, although there will be recommended changes to attorney rules. Randy or Andrew, do you want to add anything there?
So I'll jump in.
Go ahead.
Go ahead, Andrew. Go ahead.
Please, you go first, Randy.
So the Committee on Professional Responsibility and Conduct is really charged with really 2 key tasks. One is developing advisory ethics opinions. The other is assisting with considerations of other proposals concerning the regulation of lawyers as directed by the board. And so the committee would stand ready to assist the board if there was some aspect of this that would be referred to them. And subject to whatever Andrew's comments might be, the closest thing in my mind would be possibly taking a look at the rules of professional conduct to the extent that they might involve conforming changes to the attorney rules of professional conduct, which is within the purview of COPRAC when there's no Rules Revision Commission in session.
I'll just jump in really quickly. I agree with everything Randy said. The only other spin I would put on that is when other groups or entities have put something out for public comment, the board has asked COPRAC to issue a public comment. So the Rules Revision Commission, they submit rules for public comment. COPRAC would respond to those rules during the public comment period. ADLs sent recommendations out for public comment. COPRAC was asked to issue their input. But when a group or entity is separately created and working independently on their own, I don't have a historical precedent of the committee commenting on the work of that other group outside of public comment period.
Okay, thank you. I've got Greg and then Amos, Ira, and Steve.
Thanks. So two things that I just wanted to comment on. The Supreme Court's conditional approval. You shouldn't expect a court to be issuing any order approving anything in particular. What this will probably be is the court will have an opportunity to see the full scope of the program as envisioned by the working group and the board, and have an opportunity to form an opinion about it and decide whether or not to support the program. When it comes to the rules themselves that the court needs to approve, we probably need to add into the timeline after legislative authorization a rule approval period, because I imagine, depending on what the legislature ends up doing and what they end up authorizing, there may be some changes that are needed to a lot of the rules to conform to the legislative enactments. So I imagine in that period between August, September, and January, there'll be another period in which will culminate ultimately in the court issuing an order approving the rules of professional conduct as well as the rules of court. And to the extent that it needs to approve state bar rules, it will do so then too.
Okay, thank you all.
Amos?
Thank you and good morning. Yeah, one comment and one question. For the comment, I would just like to encourage that we avoid the bifurcated process that you mentioned. And it sounds like for scheduling purposes, we're looking to do it all in September together, which is great. But I can just say there is rhyme or reason behind which regulations go in the rules of professional conduct, which go in the rules of court, which go into recommended statutes, but it is all interrelated. And I think it would be unnecessarily confusing to do them separately. So I'm glad we're going to push to try to do that all together. And the question I have is about the cost of the program. So going along with this proposal, I think we have been talking about and considering costs, but I think it might be important for us to formally develop a cost estimate and what kind of funding is necessary. So I'm wondering if that's part of the schedule as well.
It's certainly part of the schedule on the staff side, and we have developed at least the initial cost. I think it's an estimate for the first 4,000 licensees, if I'm remembering correctly. So we have done that. I do imagine that would be included in the at least a staff addendum to the working group's report. But I can certainly talk to Justice Petru about incorporating that particular topic more squarely into the agenda of the working group.
Thank you.
Steve and then Ira.
Hi, Leah, thank you. I just want to clarify 2 points. Number one, we as a working group will be discussing and making recommendations on legislative changes even though those will not be going out for public comment. And I understand why those won't be going out for public comment. Is that correct?
Yes.
And then the follow-up, will those proposed recommended changes be in the final report going to the state bar and out for public comment?
The statutory changes.
Yes.
Yeah, I think they need to be right now. I see Brady's face here. Right now, we have not contemplated that they would be finalized by September, but instead in January, for the board's meeting in January, simply from a workload perspective for the team that's doing all of this. But as I'm speaking here, someone on the fly, it does seem that it would be important to have all of it done at the same time. So
I agree, and I think that needs to be part of what goes out for public comment are the statutory changes, so the public can see how everything works, how everything fits together and works.
okay.
Thank you.
Okay. Ira.
About COPRAC, for those that don't know, it's the State Bar Committee that deals with the rules of professional conduct, which right now apply to lawyers only, but we're proposing that they apply, that rules like them apply to paraprofessionals. I hope that COPRAC's function will be the same with respect to paraprofessionals as it is now with respect to lawyers. And I also hope that starts now, I want to say, during the during the period in which we're formulating rules and putting them out for comment. Now, I'm a former member of COPRAC, and I see at least 3 other former members there, and Randy DeFentorum, the State Bar's lawyer who works with COPRAC, and maybe they have ideas about that, but I guess I mistakenly assumed that COPRAC would be involved in reviewing our proposed rules for paraprofessionals, that is ethics rules, and I hope they will be.
Okay.
Thank you, Ira. I don't see any other hands, and I'm just going to ask Leah to continue to update this timeline and what needs to happen when, so that we kind of have it on an ongoing basis. Leah, is there anything else you wanted to add?
No, it's just, I saw, it's his hand is down. Okay. No, there's not, and I will update the timeline accordingly.
Okay, so before I move to anything else, I was alerted that we direct received to our email boxes some commentary, I believe. I haven't had a chance to look at it from someone in the LA County Bar. I just want to say right now, I do not think it's appropriate for commentary to be coming directly to our email inboxes. There is a protocol and procedure for how comment is to come in. Part of that is maintaining the transparency of this group and what is happening. And I don't want there to be any risk of there being side communications happening. I don't know how the person who sent it got all of our email addresses, because it's certainly not from the paraprofessional working group page on the State Bar that lists us, but does not have information regarding how to contact us directly for good reason. That is not the way to communicate with the working group, directly to people's emails or phone numbers or however it may be. I can only presume that someone on our group shared all of our contact information. I ask that that not happen again. And I ask that whoever sent it in now not use our email addresses again for this purpose. If anyone is having any problem communicating with us, I want to hear about that. If anyone is sending in, if someone hears, if you hear from someone, I sent in a comment directly, I never heard back, I don't think it was distributed, please let me and Linda and Leah know that. We want to get the information out, but it needs to go out through the correct channels. So I am going to actually delete the email once I see it and wait to get it from Linda through the usual routes. And I will then open it and read it at that time. But I'm not going to open direct communication. Any commentary on that, or anyone disagree with me? Anyone sitting here thinking, no, I want the emails to come directly to me?
Justice
Judge, you?
Thank you. I agree with you completely. When I got it, I was wondering how the person got all of our email addresses, and it didn't occur to me that someone on the working group shared it. And I think that that's really sad, sort of a breach of trust and professionalism in my view.
And I have a number of people who are not live, so I need to make sure that my message was heard. Steve Fleischman, did you hear what I just said?
Yes, absolutely. And it did not come from me. I know you're not asking.
Well,
but-
I'm not asking who it came from. I just want to make it very clear that everyone has been listening and that this is not to happen. And I don't think I need to explain any further about why that is. Judge Wiley, you heard me?
I did, thank you.
Okay, Carolyn?
Yes, Your Honor, I heard you.
Okay. And then who else do I have? Then it's not on video. Sharon, no, Sharon, you're live. Okay, so I think everyone was live, and I'll presume everyone heard me and is not going to be sending out our direct contact information. And if anyone on this call did so already, they will reach back out to say to please delete and not use it. Okay, now let's see where we are with participants. If you would like to make a public comment, please raise your hand. I'd like to have a sense for how many people we have, and then we can figure out how to stagger things, because we are working with a lot of difficult schedules today. Okay, so let's see here. So it looks like we have 12 hands up, is that correct?
Yes.
Okay, so I'm going to ask if you could try to keep it to 2 minutes, that would be great. At the most 3. I'm going to have to put a cap of half an hour. It's 10:35 right now. We'll cap it at 11, and if we still have people, then I'll set a time for the afternoon for further commentary. But that is the most that we can possibly do this morning. So Linda, why don't you start calling people?
Jason Solomon.
Hi, Jason Solomon, Stanford Center on the Legal Profession. I want to offer an observation that leads into 2 concrete proposals. The observation is that the strength of the recommendations is driven by the fundamental understanding that in most of the cases we're talking about, the alternative for paraprofessional clients is no help at all. The problems with the recommendations, in my view, arise when we forget that the alternative is people on their own and mistakenly believe that the alternative will be a lawyer. This largely plays out with respect to decisions to exclude certain kinds of cases or certain kinds of tasks within cases. For most of these decisions to exclude something from paraprofessional scope, you need to be able to say and believe. Paraprofessionals should not be allowed to do this because litigants are better off handling it on their own. If you can't say that and don't believe it, then it should be included in the scope of what paraprofessionals can do. This brings me to a few concrete suggestions, particularly in housing, but it could apply to other areas as well, such as a decision to exclude wage and hour actions in court. When housing cases go to court, we can be fairly confident that most paraprofessionals will be representing smaller landlords and not tenants. That's what we've seen in Ontario, the one place in North America where such a program is up and running. And we heard from the person in San Francisco Eviction Defense Collaborative, referenced in the memo, that only 15% of tenants she sees can plausibly afford a paraprofessional, let alone will decide to spend their money on one. In that context, I don't think the decision to exclude paraprofessionals from conducting trials in housing cases makes sense. The rule seems driven by understandable concerns around undermining right to counsel programs or legal aid. But
30 seconds remaining.
A very small percentage of paraprofessional clients will qualify for right to counsel or legal aid. Why should a paraprofessional not be able to represent a smaller landlord at trial? The memo also mentions not wanting clients to feel pressure to waive the jury right, but that would not be a concern if paraprofessionals could do both bench and jury trials. I think there is an easy fix here. You can change the rule to say that paraprofessionals cannot represent someone at trial if they can get an attorney through a right to counsel or legal aid program to represent them at trial instead. The related suggestion, I know I'm out of time, is that you eliminate the general restriction on paraprofessionals representing organizations. in the regulation subcommittee memo. I'm not sure why that is in there, so I may be missing something, but some mom and pop landlords may have created an LLC or other entity for their rental property. And
Okay, your time is up. Thank you.
Well, thanks so much. Bye now.
Peter Weinberger.
Hi, thanks for letting me speak. I realize you got a busy day, so I'll speak quickly. My first concern is having non-lawyers own law firms. That's really going to destroy the duty of loyalty, because you go from having a duty of loyalty to a client where, regardless of even whether you're getting paid, you still have to represent the client until you get relieved by the court. You'll switch that to it being solely a profit motive, and I think that's a very dangerous precedent. The other thing I'd suggest is, right now, a simpler solution is for people who have cases that don't make sense for lawyers because they're too small. We should raise the level of small claims court. I think there's plenty of cases that are $15,000 and less that people could handle quickly and efficiently in small claims court themselves. The other thing is I understand that you are limiting what cases can be handled by paraprofessionals. One category that I would recommend is contractor disputes, small contractor disputes that could be handled through the Contractor State License Board through a mandatory binding arbitration. And the last thing I'd say is you're really leaving the public at risk. And if you're going to go and let paraprofessionals, people who aren't lawyers, wing it in court, you should require them to be insured. Let them put up a bond equivalent to the amount at stake in the case. They're going to represent somebody in a $50,000 case. Let the person have $50,000 in insurance that they can go after if the
30 seconds remaining.
That's okay. I'm done right now. Thank you.
Okay. Kelly McVeigh.
Hi, Kelly McVeigh here with Betzetic Legal Services and our employment rights team. I'm an attorney who focuses on unemployment insurance issues personally, but our team handles wage theft, worker safety, gender discrimination, and a number of other employment rights concerns. It continues to be Betzetic's position that we believe all Californians deserve access to justice, and there's particular need for free services for low-income individuals within the state. We still voice concern about the viability of a paraprofessional program moving forward and recommend strong safeguards for the protection of the public. We're concerned that this paraprofessional program still risks diverting resources from free legal aid programs for individuals who could not afford an attorney at market rate, and creates another form of expensive service that many Californians will be unable to afford. We also worry that there will be added legitimacy with this program due to the state bar support, but that there may not be the guardrails that shape the practice of law by attorneys and supervised paralegals that protect the public from malpractice. Fundamentally, we still have concerns that profit motives on behalf of paraprofessionals could result in substandard services for economically vulnerable low and moderate income earners in the state. We worry that members of the public will not have clear understanding of the differences in experience level and services offered by paraprofessionals and attorneys, and continue to voice concerns over potential questionable solicitation practices, aggressive fee structures, and we would like to see clarity on disciplinary procedures for paraprofessionals. To that end, we hope that the bar will demand strict and clear disclosure requirements for all paraprofessional services.
30 seconds remaining.
Forward. We're heartened to see that the Employment Committee has chosen to restrict paraprofessionals in this practice area to assist with DLSE hearings and limited jurisdiction hearings in Superior Court. We look forward to continuing to work with the bar to shape access to justice throughout the state and to make sure that individuals receive appropriate and affordable assistance. Thank you.
Linda Spiegel.
Yes.
Oh, shoot. I apologize. Please begin again.
Am I muted?
No longer. Thank you.
Okay.
Sorry.
I apologize. I hope you can give me the time back since I did hit.
Yes. Yes.
Linda Spiegel, I am the president of the Beverly Hills Bar Foundation, and I actually came from the background of a paralegal before law school. So I understand the need and I understand the capabilities a paralegal might be able to provide. However, I want to give my support to all the comments that came before, especially the issue of guardrails, especially the issue of allowing non-lawyers to go into business with lawyers. There are protections and guardrails for lawyers now for a reason. I also want to remind the committee that the state bar outlawed protections for notarios who are essentially paralegals. And now it seems as though the state bar wants to allow that kind of schematic, but it has to realize there were bad notarios for a reason. And if you're going to allow non-lawyers, people who have not been educated in the law fully as a lawyer has, and allow them to appear in court, you're going to end up with more malpractice cases than you already have the courts dealing with. I understand that there is a cost to this. I'm concerned as far as putting out money. I don't really understand why that's being permitted. And the last thing I want to say is the Beverly Hills Bar Foundation has a modest means legal services, and that is precisely to fill the justice gap between those people who don't
30 seconds remaining.
Free legal representation, and for those that can't afford market rates. And I'm happy to elaborate on our program. And I think that's the kind of service that needs to be provided. Lawyers at modest means rates, not non-lawyers. Thank you.
Erin Joyce.
Thank you so much. I appreciate you giving me an opportunity to speak here with respect to the proposals being considered by the Paraprofessional Working Group. Now, I want to focus in on what my expertise is, which is the rules of professional conduct. I'm sure most of the people on this call are aware it took 25 years and 2 separate rules revisions committees to come up with the current rules of professional conduct. And many of the changes, especially to the advertising that are being considered now, were tried and did not proceed into the current rules. And when you're considering wholesale changes, allowing fee sharing with non-lawyers and allowing the relaxation of the rules of professional conduct in the name of access to justice, I think it's very important that it be only done with due consideration. And frankly, seeing the truncated timeline that was being considered at the beginning of this meeting, clearly the Paraprofessional Working Group is not here to consider the type of changes to the rules of professional conduct and a whole separate rules of paraprofessional conduct that would be required for this program. The purpose of the rules of professional conduct are not to protect attorneys. It is to protect the consumer. And the primary purpose of the state bar is to protect the consumer. And I think that's something that's lost by most of these proposals. We're considering very short and very limited education for
30 seconds remaining.
And in watching the regulation committee, the idea of full court representation up to jury trial. Many important rights of clients are considered all the way up to a jury trial. And to think that someone with an 8-month or even a year's worth of education can make those changes and those decisions, I think is improper. Quality and competence of legal services will be seriously undermined by most of what is being considered by this group. I believe that it should be quality of competent attorney services provided to really support the underserved communities. Thank you.
Peter Kunstler.
Good morning. Thank you for allowing me to talk. I believe that one of the main comment I have to make is that I think that the notion that allowing paraprofessionals to serve consumers misdirects the solution or potential solution to any access to justice. A large part of the issue with access to justice is caused by the high cost of litigation, regardless of who is representing the consumer within the litigation. And that won't be remedied by allowing paraprofessionals to replace lawyers. And I want to echo what Erin Joyce just said, also in the sense that the paraprofessionals who represent consumers will nonetheless be facing trained, experienced lawyers and will be outgunned, quite frankly, with the experience that they are facing. And I don't think that helps the consumers in any way, in any way at all. One other comment that I have to make, and I have a couple of proposals. One other comment that I have to make is that as a
30 seconds remaining.
certified specialist in legal malpractice law, I've noticed that the state bar disciplinary system is already overburdened. And I question whether or not, regardless of whatever rules are put in place or whatever structures put in place, that the addition of paraprofessionals will be held under control. And I think further that one of the ways that you could adopt a
Thank
solution.
you. Your time is finished. If you can wrap up quickly.
Thank you.
Jeannie Harrison.
Good morning. Can you hear me?
Yes.
Okay, great. My name is Jeannie Harrison. I'm a plaintiff's employment attorney of 28 years, top in the field, according to the Daily Journal, Super Lawyers, et cetera. And I'm president of Consumer Attorneys Association of Los Angeles. I tell you that so that you know who I am. And the reasons why I have the following comments. Consistent with the reasons why this working group has refused to allow paraprofessionals to represent employees in all other employment claims, the group should protect low-wage workers by refusing to allow paraprofessionals to represent employees in any forum. In employment law, the alternative is not employees handling cases on their own. In the Justice Gap survey, there were only 12 respondents who said they did not get representation on an employment case due to cost. 12. All of the others who sought representation in employment cases were represented. From these 12, the study declared there was an emergency in the need for employment representation, but that flatly is not correct. First, the study did not even ask the respondents whether they were told that their case had no merit, which is true of 95% of the cases that walk through my door. Second, the fact is that meritorious employment cases will be picked up by lawyers on a contingency basis. And even if there is more need for representation of low-wage workers, the answer is to incentivize more lawyers to take on these cases, because
30 seconds remaining.
The abuses in employment cases are due to the power imbalance. Paraprofessional representation creates a two-tier justice system with low-wage workers getting shortchanged yet again. And the power imbalance is real. And that is the reason why CELA, the Organization of California Employment Attorneys who fight for employees' civil rights, is flatly against the paraprofessional representation of employees in any forum. So I strongly urge this group to close out the employment issues and disallow paraprofessional representation of employees in any forum. Thank you.
George Stragas.
Yes, hi, can you hear me?
Yes.
Okay, just some brief comments. I've been interested in this paraprofessionals program and the sandbox since the inception. I have to tell you, it's extremely difficult to find information as to how to monitor what you all are doing. I think that you have a bias, whether intentional or not, thinking that us lawyers are just involved in economic protection and that we don't have legitimate opinions about what you're working on. We do. We need to be part of the process. Most lawyers have very little information about your work, the sandbox, the paraprofessionals program. They don't know that you're intending to allow Silicon Valley to own us, basically, invest in our firms, and basically turn what was a profession that we all invested our careers and a lot of money in, and what law students are certainly investing a lot of money in, to becoming a mid-level wage paying job. We have a voice. We're actually, funding all of this with our dues, and nobody wants to hear from us for some reason. And I have a cynical point of view that the reason why you're proceeding so quickly is because right now, most lawyers are unaware of what you're doing. Most lawyers are even
30 seconds
unaware
remaining.
of the split between the State Bar and California Lawyers Association. So I would encourage you, if your interests or if your intentions are well-meaning, to make sure that more lawyers are aware of what you're doing and invite our participation in comment. Thank you.
James Gorton.
Yes, good morning. My name is Jim Gorton. I'm a estate planning and probate attorney in Pasadena. I've been in practice for 40 years, and I'm a certified specialist, certified by the State Bar of California. I would endorse the prior speaker's comments on the undue haste that I see this committee plunging forward with numerous and complicated initiatives that really should be given more time. In order to close the justice gap, a radical reordering of the delivery of legal services is proposed, one involving the use of paraprofessionals backed by AI. It's proposed that paraprofessionals be allowed to deliver legal services through firms, the owners of which need not themselves be licensed to deliver legal services. This is a novel and bold proposition, one which would set aside the hard-fought consumer protections of the last century, during which the State Bar has been in existence, protections making client information sacrosanct, forbidding conflicts of interest between providers of legal services and their clients, among others. What seems to have been overlooked in the rush to overturn the existing market for legal services is any guarantee that the firms poised to develop and deliver AI-driven legal services will in fact deliver those services. There are no written guarantees of this, nor any security, monetary or otherwise, for the vague promises that the applications developed will not simply cherry pick the richest
30 seconds remaining.
lucrative areas of the legal market and leave the poor unserved as usual. Given that the poor really need assistance in such mundane courthouse matters as domestic violence, restraining orders, family law cases, and unlawful detainer, what realistically could AI do for most of these people anyway who can't afford any level of cost? And what happens when AI gives the wrong answer to a lightly trained and inexperienced paralegal? How will it be held responsible? This committee is contemplating a revolutionary change in the delivery of legal services. Should we not find out before making the leap whether the tech industry can in fact close the gap to provide legal services to the poor and obtain meaningful guarantees backed up financially before doing so?
Okay.
Christopher, oh, I'm sorry.
Yeah, I just wanted to jump in and make sure that our public commenters understand that this group is not addressing the use of AI to deliver legal advice, not addressing tech company ownership of law firms. So the non-attorney ownership proposal that is on the table today for discussion is very narrowly limited to paraprofessional attorney relationships. And this working group is only looking at the licensing of human paraprofessionals to deliver legal advice. Okay, go ahead, Linda.
Okay. Christopher Ingalls.
Thank you. Can you hear me?
Yes.
I concur with all the comments that have been made by my colleagues prior, so I'm not going to beat a dead horse. This is just a horrible idea all the way around for what has already been said. I've got a few comments. The small claims cap was brought up. Raising that cap, I think, would be extremely important in getting litigants into court and getting their own issues resolved. Everything costs over $10,000 these days. That's our cap. It definitely needs to be raised. There was another comment that we could shuttle maybe some of the responsibilities like over to CSLB. I do a ton of construction law. CSLB is so backlogged, we can't put anything more on another agency that's already behind, especially after the pandemic. So I'm just gonna close with, I concur with everything that has been said as far as against this program. A ton of attorneys here in Orange County are against it, and we've been emailing through the Orange County Bar listserv, and I was asked to show up today because I was available, and there are a ton of attorneys here in Orange County that are vehemently against this program, and it needs to be terminated.
Tamila Jensen. Tamila Jensen.
Hello. Can you hear me?
There's a very bad echo.
Can you hear me?
You're getting a lot of feedback.
So let's go to somebody else and I'll really work on your sound.
Yes.
Okay, thanks.
Matt Price.
Good morning, everybody. I am an attorney here in Orange County practicing plaintiff's personal injury law. I just echoed the comments for everybody that has gone before me. I think this is an incredibly bad idea. One of the things that strikes me is that California prides itself on being a state that has one of the hardest bar exams in the country. We have one of the lowest admission rates in the country. And in fact, we don't allow reciprocity with any other state. If we wanted to increase the access to justice, we wanted to decrease the level of cost to the consumers, why would we not first open our doors to other individuals that have been trained as attorneys in other states, that have passed bars, have open practices, and allow them to come here and compete in our marketplace because they've already proven their competence elsewhere? It's incredible to me that we're seeking to let paraprofessionals come in when we have a country of other attorneys that could just as easily provide those same services. And it's also striking to me that we believe that the state bar is somehow going to be competent enough to regulate paraprofessionals when just in the last few months, the stories that are coming out of some of the most high profile lawyers in the state and the scandals that they have been tied to, widows and orphans being deprived of millions of dollars, corruption with judges and high profile attorneys. How does the bar intend on regulating that new area of paraprofessionals when we can't already regulate our own? We hear reports constantly.
30 seconds remaining.
We hear reports constantly of attorneys having presences in hospitals, paying people. I myself have reported countless attorneys to the bar and nothing happens. If we can't regulate our own, how do we regulate a brand new industry? Thank you.
Okay, I'm going to try Tamila Jensen, if you want to try again. Hello, Tamila? Okay.
Hello, can you hear me now?
No, we're having the same problem. I'm
Same
sorry.
problem. Sorry.
I wonder if are you also called in on your phone?
No, my phone is off.
Okay.
Yeah.
Okay. Now we have someone that we just have by phone number ending in 2500. You're muted. If you want to unmute. Person with the phone number 2500. Okay. I'm going to move on to the next person, Lauren Johnson. Oops. Lauren Johnson, if you unmute yourself.
You. Linda,
very much.
This is Yolanda. Can you hear me?
Yes.
Okay, I had said we were going to stop at 11 o'clock and it's 11:02 right now and we have 7 hands still up. So we're going to pause on public comment for now and resume at 3 o'clock this afternoon with anyone who'd like to make comment. Leah, what's our next agenda item?
Next up, we have Brady. So we're going to move into the rules discussion, but we're going to start off with giving the working group a sort of comprehensive overview of how we are tackling all of these different components, not just the rules of professional conduct, but the other rule and statutory changes that need to be identified and drafted. Then we are going to move to hear from Mark Tuft and others about the relationship between some of the issues being addressed or vetted by this working group and those under the purview of the Closing the Justice Gap Working Group. That's at the request of one of the members of this working group wanted to talk about the overlap. And then we'll move into the discussion of the draft rules of professional conduct. So Brady, why don't you go ahead?
Sure. Hi, everyone. Good morning. So I'm here to give you a brief overview to make sure you're all aware of some work that the Office of General Counsel is undertaking currently and over the next few months to help assure that we're able to develop comprehensive and workable proposed rules and statutory changes to implement the program on the timeline that Leah discussed earlier. As this working group has done its work, some members have raised concerns regarding statutes and regulations that the working group has not yet formally considered that may or might need to be changed in order to implement the paraprofessional program. One example of this that's come up a few times would be the evidence code's provisions creating the attorney-client privilege. Presumably, a coextensive privilege should apply to licensed paraprofessionals who are performing the practice of law tasks that they are authorized to do under the program. But again, this is not something that we've considered yet. So to assure that all such issues are identified and, if appropriate, brought before the working group before it completes its work, OGC is assisting in answering two broad questions. First, has the working group considered all the issues necessary to stand up the program it's contemplating? And two, what statutes or rules, be they rules of professional conduct, rules of court, rules of the state bar, rules of procedures of the state bar, must or may need to be either adapted or amended to stand up the program. Next slide, please. To that end, I'm coordinating a team of 8 Office of General Counsel attorneys to perform research to answer those questions. Additionally, the Office of Professional Competence, led by Randy DeVitorum, has already embarked on a review of the rules of professional conduct, which Randy will be presenting today. So that's the first bullet there. Other research areas include review of the State Bar Act, Evidence Code, and Code of Civil Procedure for references to attorney, counsel, etc., so that we can determine whether statutory changes in those areas are necessary. We were also undertaking a review of the functional areas of the program, those being governance, licensing, and regulation and discipline. Those basically we're going to be looking at the existing state bar rules and rules of court in those areas and making sure that all of the issues that are involved in setting up a program, a licensing program, have been addressed by the committee. And if not, if there's something we've missed, we'll bring that to the committee's, the working group's attention. And finally, we will be undertaking a review of the substantive areas that are under consideration, beginning with family, housing, and collateral criminal. We're starting with those 3 areas because of their inclusion in the initial rollout. Review of additional practice areas will follow at a later date. The attorneys here will be looking at the various tasks that paraprofessionals in those areas will be permitted to do, and they'll search the relevant law to identify any statutory or rules changes specific to those areas that might be needed to permit the paraprofessionals to actually do the work that they're authorized to perform under the program. So essentially, we're going to be a second look at all these programs and make sure that nothing's been missed so far. Next slide. The process and schedule that we're looking at is that by the end of May, the OGC team will complete the research and identification of the outstanding issues or statutes or rules that need to be changed. So we'll be doing the research and issue spotting over the next month. Then any issues that involve unanswered policy decisions will be brought forward to the relevant working group committees and or the full working group. And I think there's a mistake here. It's actually going to be at its meetings in June, and then July or August is necessary. Correct, Leah?
Yes.
Okay. Examples when I say unanswered policy questions that we will likely be bringing to the working group, those could include, as I mentioned, bringing to the working group a recommendation regarding the evidence code provisions on privilege and whether a coextensive privilege should be created for paraprofessionals. Another example would be the IOLTA statute. That's a part of the State Bar Act, which requires attorneys who hold client funds to place those in an IOLTA account if if the funds aren't large enough or being kept long enough to generate interest for the clients. So a question would be, should any paraprofessionals who hold client funds be required to open IALTA accounts as well? There may, on the other hand, be certain statutory or rule changes identified that don't need explicit working group instruction. As a hypothetical example, one could imagine a penal code provision stating that expungement papers must be prepared by the defendant or, quote, their attorney. Here, since the working group has already recommended that paraprofessionals be allowed to assist in expungements, a separate working group decision wouldn't be needed regarding that statute, because obviously, in order for the recommendation that paraprofessionals be allowed to do expungements to take effect, we would need to change that statement, that statute, excuse me. Next slide, please. So in essence, we have two goals in this research that we're performing. Number one, ensuring that the working group has the opportunity to consider any outstanding policy questions that it has not yet considered. And number two, ensuring that staff has sufficient information and direction from the working group to draft the statutory and rule changes necessary to implement the program and put forward for public comment at the end of the year. And so that's an overview of the work that we have started undertaking and we'll be doing over the next month. And let me know if, or please, any questions.
Thank you, Brittany.
Sure. I was just going to say, and the last thing I'd say, either being at meetings, examples of various working group members, as I mentioned, have mentioned areas like the evidence code that they think that we should consider. And I think I've all of that is filtered up to me, but if anybody has any ideas or questions or things that they think that our group should look at, feel free to email me, reach out to me directly.
Great, thank you. I don't see any hands up. So we are going to turn now to Mark Tuft. Thank you so much for joining us today, Mark. And I would love for you to start off just with a brief introduction of yourself. And Randy and Andrew, I know that you will, and Kevin.
So Mia, I see Carolyn's had her hand up a little bit.
Oh, I'm sorry, I didn't see that, Carolyn. Go ahead.
Yeah, I just, Brady, are you preparing a report on this like you've done with the, yeah, I think you gave us at least one report, but will there be a report from you on the things that you just put together, the overview?
Well, so really what we're doing right now is identifying any areas where a recommendation would be needed. And so for instance, I anticipate, I think in June, Leah, we would bring forward a recommendation regarding the statutory privilege in the evidence code. Until the work over the next month is identifying issues such as those, and those will individually be brought forward.
So we won't see those in written form until June?
I don't expect that you'll see anything in written form until June.
Thank you.
I think was Stephen's hand up also?
Yes. Brady, I have comments as it relates to the draft rules you circulated about fee sharing and referral fees. Are we going to talk about that now or later today?
Later today.
Thank you.
Okay, so with that, I'm going to turn to Mark. Thank you so much for joining us, Mark. We also, as I started to mention, we have Randy and Andrew here from the Office of Professional Competence, and we have Professor Moore here, who you all have heard from previously. But this brief sort of contextual segment of our agenda is to specifically address any potential overlap between some of the proposals that you all are being asked to discuss today. Steve teed some of them up, and the work of the Closing the Justice Gap Working Group in the second instance, and in the first instance, the access, the task force on access through innovation of legal services. So Mark, if you could start us off, introduce yourself briefly, and then I'm not sure how some of the others might want to jump in But again, the purpose of this discussion is to provide the working group with that context of any potential overlap with respect to the rules issues being contemplated.
Good morning, and thank you for the opportunity to speak with you. I'm Mark Tuft, and I am a former member of the ATILS task force. I've been involved with a law governing lawyer for probably close to 50 years, and am a co-author of the Ritter Group Practice Guide of Professional Responsibility, and have served on many commissions, the Rules Revision Commission, task force, including the Multidisciplinary Practice Task Force back in the 1990s, which has a certain ring as we are now revisiting some of these issues now in the 21st century. Very simply put, ATILS, as I'm sure you're aware, was a policy-driven task force that looked at a large group of issues involving improving delivery of legal service models in a variety of contexts from a policy perspective. And we came up with two overarching recommendations, basically to look at whether or not there ought to be amendments to the prohibitions against the unauthorized practice of law, to allow non-lawyers to deliver legal services, both through a paraprofessional program and in a much broader sense through technology-based delivery systems and the like. And so that was one overarching recommendation. The other one dealt with looking at the restrictions on fee sharing with non-lawyers and non-lawyer ownership of law practice. And in that regard, we recommended that the Rule 5.4 be looked at both from a short-term perspective, which involved amending the rule to allow for the sharing of fees with qualified nonprofit organizations, which has been accomplished, and a longer study that deals with entity regulation, alternative legal service providers, ABSs, and ownership issues. So there were 7 recommendations. In terms of the rules themselves, we recommended that a study group be formed to look at Model Rule 5.7 on the delivery of non-legal services by lawyers and lawyer-owned businesses, or businesses owned by lawyers and non-lawyers, that would complement what is going on in the legal services industry today in terms of the provision of law-related services that are in conjunction with legal services. So that was one separate recommendation. We also recommended studying amendments to the Certified Lawyer Referral Service rules and regulations, particularly in view of the fact that there are a lot of online portals for client generation and referring of clients to various lawyers and the like. And so we thought that that those type of restrictions should be examined. And we also recommended that attention be given to amendments to our advertising rules in view of the clearly demonstrated need of getting more truthful and non-misleading information to consumers about the existence of legal services in a variety of ways. So all those recommendations were made. They are in the form of a menu approach. So they were not mutually exclusive by any means. The task force had long discussions and received reports from a variety of sources on all of these issues. And it was intended, at least my recollection, Kevin can comment on this if you like, but my recollection was that we wanted a broad approach to this very important problem of narrowing the justice gap in a variety of ways. And the paraprofessional program was one of a menu of choices, not to be influenced, frankly, by working on other recommendations. And so if you look at our report, and when we get to that recommendation on the paraprofessional program, you'll see that we lay out certain concepts. We did not preordain how the program would unfold. There are a variety of models and formats. You can look at the Triple LT program that's been developed in Washington. You can look at the Utah program. You can look at a more incremental program. There was a lot of input we received from experts like Professor Sanderford, who had wonderful ideas and suggestions about limited task-based provision of legal services that will allow consumers to learn if they have a legal problem, and if so, what that legal problem was and what the alternatives are for helping them solve that problem. So it was a broad range of ideas, none of which resulted in a one-size-fits-all recommendation for your working group. And whatever program you come up with, however broad it is, what is the level of service that you're going to recommend that paraprofessionals perform, that invariably will implicate various rules of professional conduct for lawyers. It will implicate statutes. It will implicate rules that will govern the rendition of those services by paraprofessionals. That, in my judgment, was all within the assignment in that recommendation, which I think is recommendation number 4 in our report. So the bottom line, I think, is that, and I know we were told this at the ATELS level, is that the State Bar and ultimately Supreme Court is looking for the best recommendations, the best input, the best advice that they can get from these individual working groups, without regard to what is going on in some other working group. So at least from the ATELS perspective, I don't think there was any restrictions placed on the paraprofessional working group in terms of rule recommendations or how to fashion the program or what restrictions they should have or what level of service these licensed paraprofessionals should have. So I think those are my comments. I'll answer any questions that you have, but I hope, Leah, that's responsive to your request.
Sure. I don't know if there are any comments, or if Randy or Andrew or Kevin, you wanted to address this question of potential overlap or issues being addressed by both the Closing the Justice Working Group, Justice Gap Working Group, and this one, particularly with respect to the proposals being considered today.
If I could just jump in briefly on the concept of overlap, I've tried to follow the work of this group to a certain extent. You're very busy, you're very productive, and I haven't been able to keep up as well as I would like to. But I don't see where there is all that much overlap, because as Mark mentioned, there were 7 separate recommendations of the ATELS work task force, only one of which addressed the issue of paraprofessionals. The other issues that he's already mentioned, looking at Rule 5. A new Rule 5.7, consider Rule 5.4, the lawyer referral service rules, and in addition, the advertising rules. Those are all on the menu to be addressed by the Closing the Justice Gap. At present, however, right now, the working group is focused on developing recommendations for the regulatory sandbox, which I don't see where there is any conflict with the work of this group, to the extent that there are going to be proposals. If a proposal is going to concern, say, a paraprofessional, I think that proposal would go through your group rather than the Closing the Justice Gap Working Group. So there is very little overlap, other than we are going to be concerned with studying, researching, and perhaps making proposals about rules changes that might be required in order to facilitate the operation of the regulatory sandbox.
Okay, I see Carolyn and then Steve.
Okay, so I have a number of questions, and I guess I can focus them on Mark, although I know Kevin. but thank you both for your work on the ATILS committee. I know the both of you put in a ton of time and energy on that committee, and I've read your reports. I can't say I remember any of them. I tried to dig them up for today. I will certainly dig them up before June. They're incredibly complex. And one of the things I remember from July, the July before all your memos came out, was the red line proposals. There were numerous red line proposals to 5.4, some in the 7 series, and I don't know about the 8 series with regard to advertising, with regard to all the things you said, referrals, and not lawyer ownership. And I know some of those were proposals following the ABA new rules that were not adopted in 2018. So my question, I've got 3 questions, actually 2 questions. One is that, isn't it true that the only thing that ATILS adopted and recommended at the end of the day was the changes to 5.4E, which allowed nonprofits to additionally share in referral fees to private attorneys? Wasn't that the only one, and all the other red line, very carefully thought out proposals were not adopted?
If I,
Go ahead.
There were 2 that actually went over to COPRAC for further consideration. One was the 5.4, the change to 5.4E. COPRAC recommended that it be broken out as a separate subdivision F. And there was also a change to the comment about technology in Rule 1.1, the competence rule. Both of those were approved by, eventually went out for public comment, came back, were revised, went up to the Supreme Court, which approved them effective March 22nd of this year. So there were 2 rules, but otherwise, the other red lines that you saw, no, they didn't go forward because they were viewed as something that would be better considered by the subsequent rules groups.
Okay. And then,
And I think, let me follow up on that. If you look at our report, you'll see that the ATILS had recommended a certain short-term proposals and certain longer-term proposals. 5.4 actually falls into both of those categories. There was some drafting. I know Kevin and I worked on drafts for 5.7 and the like, but as Kevin mentioned, that work has now been transferred to the Justice Gap Working Group. They have the benefit of it, but we didn't reject any of the proposals. We simply thought we would summarize our work in those 7 recommendations without tying the hands of any of the supplemental implementation working groups. So whatever drafting we did is available for the working groups to look at. We didn't reject them necessarily.
okay. And then the second question is, I think Professor Moore, I think you were on the Closing the Justice Gap group as a committee member. And I'm just wondering, have you read the regulation proposals or listened into any of the regulation proposals here and compared them to what Utah is doing and has done?
When you talk about
yeah,
about
yes.
paraprofessionals, I haven't gone into a deep dive as to what Utah's done with paraprofessionals. What I've been focusing on is the Utah regulatory sandbox, because that's really what we've been focusing on in the Closing the Justice Gap Working Group.
Okay, thank you.
If I may, I'd like to make one further comment just to clarify. There was some comment about the advertising rules. At the time the commission studied the advertising rules, the ABA rules were 7.1 through 7.5, and that was the models that the commission was looking at. While those recommendations are being finalized, the ABA met in the summer 2017 and adjusted their advertising rules. So now they have only 3, 7.1 to 7.3. The commission did not have an opportunity, given the time frame it was given, to study those recommendations. And so when ATILS looked at that, they believed, I think Kevin would agree with this, that we believe that that should be looked at. And so although we did not draft them, because we were a policy-driven task force. I think our recommendation was that because other states like Washington and Oregon and Virginia, others have modernized their rules in light of technology, that a working group should look at the advertising rules. So that is one of our recommendations, even though we didn't actually draft them and send them out for public comment.
Okay, thank you, Steve, and then Ira.
Hi, I'm Steve Fleischman. Thank you both for coming today. My comments relate to the potential for overlap between our group, excuse me, and the Sandbox group. Right now, lawyers cannot share fees with non-lawyers and cannot pay referral fees to non-lawyers. My understanding is the Sandbox group has been given specific jurisdiction to address that rule, specifically Rule 5.4. And yet at the same time, we are considering the same type of proposals in our group. I don't see how there isn't overlap on that issue. I don't see how there isn't potential for inconsistent rulings. And my personal view is our group should stay out of that in favor of the group that's been specifically asked to opine on that issue. Tell me I'm right, tell me I'm wrong.
Okay, if I, to answer your question about 5.4, although the rule is being studied, it is also going to be considered in light of any proposals that are submitted to the Sandbox once the Sandbox is up and running. Just by reference as to what Utah has done, is that Utah, instead of making a massive change to its Rule 5.4, which is probably a bit more lenient than in California, has a provision that specifically refers to its regulatory sandbox, which is what we might end up making a recommendation on the working group. We haven't gotten that far. We haven't looked into the details of 5.4. But in other words, an exception is that lawyers would be able to share fees to the extent that it might be permitted under the regulations of the regulatory sandbox. So that might be the only overall change to Rule 5.4 that might be recommended, rather than making a large change, a recommendation by the closing the justice gap group. So it's difficult to say. We haven't gotten that far. And I understand the concerns you have that you might be making changes, but the focus, as I see it right now, where the Justice Gap Group is going, is to focus on the regulatory sandbox and maybe step back. So if you're making recommendations as to changes as to 5.4, I'm not sure that that will necessarily interfere with the revisions that might be recommended by the Justice Gap Group.
Okay, let me add something to your question from an ATIL's perspective. That the dichotomy at the ATIL's level was that the paraprofessional program, as Lee has mentioned earlier today, deals with licensing individuals to render legal services and a relaxation of UPL rules. In designing that program, you will necessarily be considering whether or not that is a standalone program that does not involve lawyers, or a program that works in concert with lawyers, and whether they can deliver those services with lawyers in a combination of services under a existing institution or association or organization. Those are within the purview of the licensing program for paraprofessionals. The sandbox approach and the larger issue of technology-driven delivery systems will invariably deal more in light of entity regulation. So I don't see a significant overlap between recommendations of a paraprofessional practice organization group that deals with whether or not there is fee sharing or common ownership with lawyers, because your recommendations will be they work with lawyers, they stand alone, they can or not, whatever your recommendations are. That will be within the purview of that program. How that fits with the working group on entity regulation, we'll have to see, but and I'm speaking for myself now, but I did not see any problem with the paraprofessional group addressing those issues in the context of licensing of individuals.
Well, let me sort of cut to the chase. If we recommend no, paraprofessionals should not share fees with lawyers, and Sandbox comes up and says, yes, 5.4 should be changed. Lawyers should be able to share fees with non-lawyers, including paraprofessionals. There's conflict there. On the other hand, if we say, yes, paraprofessionals should be able to share fees with lawyers, we're sort of tilting in favor of that as it relates to your group, that people in the Sandbox group will be able to say, look, they've already approved that for paraprofessionals. This is just the next step. It just seems to me we should just stay out of that and let your group do its thing. The Sandbox group, I mean.
Mark, do you want to address? I see Greg and Randy's hands up. Greg, do you want to speak to this question? Randy, yeah, just jump in at this point.
I'll just make just one comment. I do, Steve, I do agree with you. There is overlap to the extent that we, both groups are being asked, potentially being asked to look at Rule 5.4. This group is being asked to look at it in a much narrower way, whether or not lawyers should be permitted to share fees or provide referral fees to other licensees of the state bar. The Closing the Justice Gap group is looking at it much more broadly. They're looking at 5.4 and deciding as a recommendation whether or not lawyers should be permitted to engage in those activities with non-licensees, with non-lawyers, with entities. So they have a much broader charge than this group. That's the first thing I want to say. The second thing is there's no concern with adverse rulings between these two groups, because neither group is being asked to rule on anything. You're just being asked to provide recommendations. And the decision makers on that first are going to be the board and then ultimately the court. And as I've said before, I don't think the court is going to be confused if they get one set of recommendations from one group and another set of recommendations from another group. If the court gets this group's recommendations first, and this group does recommend that there should be that type of fee sharing and referral fees between lawyers and paraprofessionals, and they approve it, then I think the Closing the Justice Gap group will adjust to that. That doesn't necessarily mean that they are going to recommend that we should expand 5.4 even further. So there's no concern with adverse rulings here, because all we're looking for is your best thinking, as this group's best thinking on this, and the Closing the Justice Gaps group as well. And as Professor Moore said, this group is certainly, it's within your charter to say paraprofessionals should not be allowed to share with anyone, even among their own other paraprofessionals. But you should I think you should make that decision based on the policy rather than concern that you're stepping on the toes of this other working group.
Thanks, Greg. Steve, did you have anything further?
No, thank you, Leah.
Okay, Ira.
I want to address a different aspect of what I think is overlap. I think everybody does too, which is ownership of firms that employ paraprofessionals. I want to first point out that a lot of the objections that we've heard in the public comment today, public comment at other meetings, and that I personally have heard in very strong ways from legal aid organizations, bar organizations, and lawyers and non-lawyers, is what I see as a great danger, and what the commentators have seen as a great danger of allowing big business, I'll put it. Somebody referred to Silicon Valley today, in the ownership of firms that provide legal services, and that in our case here that employ paraprofessionals. I think people who are concerned with that are quite correct, and I favor not allowing large businesses to be involved. In fact, I favor that no organization that employs paraprofessionals should employ more than 6 of them, which I think would eliminate the interest of big business in them. And my question to Mark Tuft and Kevin Moore and Greg Fortescue and anyone else, do you see any problem with the paraprofessional working group making recommendations on who can and cannot own organizations that employ paraprofessionals, and how large those organizations can be?
But the short answer is no. I think that you're going to be studying a lot of issues that deal with the level of service that the paraprofessionals are going to be authorized to render, what their qualifications are, to whom they are going to render services. Is it going to be related to a specific critical area of need or in a much broader way? Those are all very important issues that will drive your discussion as to whether or not those services ought to be rendered with or without the benefit of lawyers and in association with lawyers. And if you get to that point, you then can say, well, if lawyers and non-lawyers are going to be able to render these services collectively and in coordination with one another, what are the benefits and risks associated with sharing of fees that are generated from those combined services? I think that's well within your purview, and I think that's perfectly appropriate for you to undertake. That's my short answer.
Okay, don't see any more hands up. So thank you, Mark and Kevin et al. And I hope that this provides a good foundation for transitioning into our discussion of the draft proposed rules of paraprofessional conduct. So what we have teed up is an approach where we're going to have Amos and Fariba go over some of the key policy decisions that were made in the regulations subcommittee. And then we're going to have Greg describe how those policy decisions were translated into the draft rules proposals that you have today. So with that, Linda, if you could put back up the PowerPoint. And Amos, I think this is the first slide and kind of a good orienting slide. So why don't we start here? But I know it's not just an orienting slide because we're going to kick off with some of the most important proposals. So Amos.
Okay, thank you. So transitioning to the work of the Regulations Subcommittee, as previously reported in various reports that we did, we were looking at some high-level consumer protection issues of if we're going to stand up this program and license paraprofessionals, what types of regulation and consumer protection would be needed. And this slide talks about some of them. We already talked about and voted on MCLE and financial responsibility, and in particular, $100,000 bond requirement. But we also circulated draft language about a required written agreement, pre-engagement informed consent requirement, advertising limitations, and then generally rules of professional conduct for paraprofessionals that track the rules for attorneys. We're going to be talking a lot about that. But just to talk about the written agreement first. For attorneys, written agreement is required, or at least in certain situations. There's business and professions codes, 6147 and 6148. Those technically would not apply to paraprofessionals. So we were looking at and talking about when and what should be required in written agreement. We do have a draft language in the rules that were circulated in 1.5.2 that you can take a look at and provide comments on. But we are recommending that there be a written agreement requirement and that include certain specified mandatory disclosures that are in that rule. Same thing with a pre-engagement informed consent requirement. This is something that we've talked about in the working group before. It is something that was suggested that we at least look at by the ADLs. And we are recommending that there be a pre-engagement informed consent requirement, which also requires certain mandatory disclosures. We're talking about maybe creating a standardized form for use in the different practice areas, but that is a separate requirement we are recommending than the written agreement. And we have draft language in Rule of Professional Conduct 1.4.2 for that separate pre-engagement informed consent requirement with certain mandatory disclosures. Advertising limitations, we are recommending some advertising limitations. Those are for attorneys in the Series 7, Chapter 7 rules. So we're recommending some modifications. Examples of our recommended changes include that the advertisement needs to include that they're not an attorney and include a license number and that sort of changes. But those are in the draft rules at 7.1, 7.2, and 7.3 that you can take a look at. Now, I think a lot of the comments and a lot of concerns have to do with other things other than those three and the MCLE and financial responsibility that we talked about separately. And that's when we went through the rules of professional conduct for attorneys to see what should apply, what shouldn't apply. There's obvious things that don't apply. There's obvious things that should apply. And then there's a lot of policy decisions that need to be made about how they would apply to paraprofessionals. Do you have the next slide? So this is where we have a number of recommendations. And I think there's two different ways to approach this. And we've had some discussion and debate about what the best way is because it is a lot of material. But what the regulation subcommittee did was looked at the policy level decisions rather than starting with the rules or red line of the rules. And policy decisions on should paraprofessionals be regulated the same as attorneys or differently, and why, and in particular looking at consumer protection issues. And again, some may or may not apply, but we did do some policy level decisions. And personally, I think it's helpful to think about the policy level decisions before digging right into the rules and looking at how they're redline or objecting to any redline from how attorneys are regulated, because I think the policy decisions are important. The relationship between attorneys and paraprofessionals, which have been raised a number of times, mentioned a number of times, that has a lot of implications. So, for example, co-ownership of firms. Are paraprofessionals able to set up shop with other paraprofessionals and share fees? Our recommendation is yes, and that has implications for fee sharing between and among paraprofessionals. What about relationships between paraprofessionals and attorneys? Again, these are recommendations and we can discuss how we arrived at these recommendations, but our recommendations are that paraprofessionals and attorneys should be able to practice together and co-own firms together, and as long as the paraprofessionals have a minority stake. Now, there's all sorts of relationships that we just have to contemplate how it could happen or how it should be regulated. But generally speaking, at the policy level, before we get down into editing rules or redlining rules or drafting rules, I think we have to think about the policy question. Should we be prohibiting paraprofessionals from working together, from sharing fees together? Should we prohibit paraprofessionals from working with attorneys? And the same thing with the referral fees. So referral fees and fee sharing is if these professionals are working at different firms. And our general approach was to track the rules for attorneys. So attorney referral fees and fee sharing, there are rules that already exist that regulate when and where that is allowed. And our general approach was to follow the same rules for paraprofessionals as it currently exists for attorneys. Now, there's going to be a lot of discussion about this, and we're happy to go back to sort of the policy level decision of why we're recommending this. But again, as a starting point, I think that's where we started, is to say, track the rules for attorneys, which are found in rules 1.5.1, 5.4, and 7.2, related to fee sharing and referral fees when people are at different firms. And again, for runners and cappers, there is a statute for attorneys. It's a Business and Professions Code 6152. That is going on the list that Brady mentioned of laws that may need to be changed or recommended change. But we are recommending in the rules of professional conduct that it be clear that runners and cappers are prohibited the same as they're prohibited for attorneys. You have another slide? So as we dug into the rules for attorneys, there are a lot of other policy decisions that need to be made. And I think we'll talk a little bit further about each of these. But we did go through the rules to talk about how attorneys are regulated in these areas and if that should be the same for paraprofessionals. And I think we generally tried to follow the rules for attorneys, as it's been mentioned. The state bar, working groups, the Supreme Court has done a lot of work in California on the rules of professional conduct for attorneys. And our general feeling is if paraprofessionals are going to be practicing law and advising clients about law, generally the rules of professional conduct and the ethical standards and disciplinary standards should track unless we're making decisions about where they should divert. And yes.
Can I just jump in real quick and just give a little bit of background on why we're doing that?
Yes, please.
It's important. I know that you and Fariba know, because we've had a lot of conversations about it, but it might be helpful for the whole group. So as everyone knows, the rules of professional conduct for attorneys are the Supreme Court's rules. And Rule 1.0 states that they're intended to regulate the professional conduct of attorneys through discipline. They're meant to be disciplinary standards. And the stated purpose of the rules, number one, and I think we heard from one of our public commenters about this, Aaron Joyce, is to protect the public. It's also to protect the courts, the legal profession, protect the integrity of the legal system, and promote the administration of justice and confidence in the legal profession. So in other words, the rules represent a floor, a minimum professional conduct standards used by the court to regulate the legal profession. And the court views them as the most important means of protecting the public from those who are unfit to practice law. So the court has, as everyone knows probably by now, because I've said it several times during some of these meetings, has primary authority over the practice of law. So no other statute, regulation, local rule, ordinance regulating lawyers can conflict with or preempt those rules. And if they do so, those other enactments, they must give way. So to the extent the working group intends to impose additional disciplinary standards on paraprofessionals beyond those contained in the set of rules that apply to lawyers, and I think Amos has already talked about three of those: the written agreement within the rules of professional conduct, having a written agreement with some mandatory disclosures, having a pre-engagement set of disclosures beyond just the absence of malpractice insurance, and some additions that we'll see to the advertising rules. So the group can decide whether or not they want to recommend additional standards, but I can't hazard a guess whether the court will approve any of those additional recommended standards. And that of course is assuming the court agrees with the threshold question of whether paraprofessional licensure should exist in the first place. But however, what I can say with 100% confidence is that no member of the court is going to be prepared to hold paraprofessionals to a lower ethical standard than those embodied in the rules of professional conduct for lawyers. So that's a preface that I gave to the regulatory subcommittee. I wanted to help facilitate their conversation. So I said, well, where does this leave us? So it leaves us really, in my mind, with two questions as it relates to the existing rules that apply to lawyers and how we should use them to inform rules that should apply to paraprofessionals. First, as a working group, you must determine which rules are completely irrelevant to paraprofessionals based on the limited areas of authorized practice and move those rules aside. So for instance, paraprofessionals will never be prosecutors. So Rule 3.8 governing special responsibility for prosecutors can clearly be taken off the table. And those are pretty straightforward. It's a straightforward exercise to identify and remove those rules or provisions of certain rules once the full scope of authorized practice is finalized. So we'll pull out some of those provisions. We've already pulled out some provisions that you'll see in some of the red lines, because it's clear that they will not apply to paraprofessionals based on what we know they can and cannot do. The second set of questions are a bit more thorny, and that's what we're really going to be wrestling with today. So we must decide across several topic areas the extent to which a working group wishes to impose either the same ethical standards that we impose on lawyers, or do we want to impose a higher standard? And to facilitate that consideration by the regulatory subcommittee and their discussion, I attempted to go through the rules because I was the liaison to the Rules Revision Commission, and I had the benefit of Mark Tuff and Professor Moore there. I got a master class in legal ethics over a 2.5-year period, 3-year period. So I was able to identify at least 20 key policy decisions that underlie that the court's already considered and made in the last 3 years, and decisions that underlie several rules of professional conduct for lawyers, and then tried to reflect those policy issues back to them in the form of a question to obtain their recommendations. And then based on those answers, with Randy's help and Andrew Tuff's help, and I began the process of amending the rules of professional conduct for lawyers to reflect those decisions so that we would have a set that would pertain to paraprofessionals. So these third and fourth slides really capture those decisions by the regulatory subcommittee. And then the fifth, I think the fifth slide represents 2 questions that remain undecided at this point. So I just wanted to give that preface before we started in, because I think it's important for everyone to understand what, not only that's the approach that we took, but why we approached it this way.
Very helpful, thank you. And I should point out that Greg, Randy, and Andrew have spent quite a bit of time and are going to still be spending a lot of time helping us through these policy decisions and drafting proposed revised rules.
Could I chime in? Could I chime in too, just really quickly? And I think to the extent that we may be recommending harsher rule or more stringent rules than are applicable to attorneys. We balanced, I think there's 3 policy considerations mentioned here, basically access to justice, consumer protection, and the third one being, not making it too hard to enter this profession and be able to practice the profession. So the rules aren't too stringent, and rationalizing our recommendations that way.
Perfect. And one other high level note, as Greg mentioned, the rules of professional conduct are disciplinary rules at their heart. That's the purpose. And some of our recommendations in the regulatory subcommittee are for rules that don't fit in the disciplinary system, so aren't being proposed as rules of professional conduct, but are more appropriately rules of court. That would be, for example, the CLE requirements, the bond requirements, anything that's required that isn't necessarily a disciplinary issue. Of course, violation of those rules of court also might lead to discipline if they're practicing illegally or beyond the scope of practice and things like that. But that's, again, why initially I made the recommendation. These are all intertwined. So I think it would be hard to bifurcate the process and consider them separately for public comment, because it might not be clear why we're recommending something that goes in the rule of court as opposed to the rules of professional conduct. And it really has to do with the rules of professional conduct being the disciplinary and ethical rules, as opposed to other statutes or rules of court that also provide important regulations. So with that overview, how do you want to proceed into the actual where we are? So again, we're not voting on any of this today, is my understanding. We're giving an overview of the work that we've done and the recommendations, and I think we'd be very open to discussion and suggestions on the drafts that we have put together so far.
Do you want to go back and begin with the written agreement, since that was the first requirement that we know is going to be part of the group's recommendation. And just, we could talk about a bit. I mean, I can give some context. So I think we've talked about this in the past. Under California law currently, lawyers are required to enter into a written retention agreement with clients in 2 situations under the State Bar Act. Okay, so there's no rule of professional conduct that requires a written agreement with a client. The State Bar Act requires a written agreement with a client if you're entering into a contingency fee agreement, or if it's contemplated that legal services will cost the client more than $1,000. And so that's the current state for lawyers. The regulatory subcommittee feels it's very important that not only that that paraprofessionals enter into a written agreement with certain requirements for the agreement itself, but also even at the beginning of the conversation with a potential client, that they obtain their informed consent to proceed with the knowledge that the paraprofessional is not a lawyer, and providing certain disclosures as well to the client about the risks of proceeding with a paraprofessional, as well as perhaps an estimate of cost, where you have to determine that, because one of the questions I have pending for the subcommittee is, if we're that early in the process, if the trigger is at the very beginning of the conversation, presumably the paraprofessional doesn't have enough information to provide a solid cost estimate, but perhaps it's a disclosure of the fee structure that that will be used in the relationship if the client decides to move forward with that. So we have a number of those requirements. So these are 2 separate writings. That's the other important point to make. Currently, the only pre-retention disclosure requirement for an attorney, aside from if there's fee splitting or some other instances, is that you disclose that if you do not have professional liability insurance, with certain exceptions under the rule. So that's one of the reasons we place the mandatory disclosures, the pre-engagement mandatory disclosures, under Rule 1.4.2. And we made it a separate rule from the requirement for a written agreement, because we want to emphasize the fact that these need to be 2 separate writings. And then the written contract with the mandatory disclosures is appearing under a new rule, Rule 1.5.2, which follows the rule around fee splitting with paraprofessionals in different firms. I don't know if there's anything else you want to say about this, Fariba or Amos. We can also talk a bit about what other states are doing in this regard.
We do have 2 hands up, Greg, Carolyn and Steve.
Okay.
Carolyn, you want to?
Yeah, and I absolutely want to hear that comparison between other states, because I haven't had time to go and do it, and your reports are new. But I heard, and Greg, with all due respect, I heard a lot of perhapses and maybes and how do we do this is in what you were saying. And so these rules, again, is this really take years to do? So policy decisions, I think there's a requirement, in addition to what you said about the mandatory malpractice insurance, that you disclose conflicts, and those conflicts need to be in writing. Immediately you have to disclose those if there are true known conflicts. And for example, in trust cases, when there are multiple families, family members that may be represented by one person, and family law, which I am not, again, I am not as well versed as Steve Hamilton and some of the judges here on this panel, but I know there could be in the simple representation of both sides in a non-contested divorce, you may have to disclose those kinds of conflicts. And one of the things that I had concern with was, how big a type do you have to make those? The State Bar current recommended fee agreement is about 8 pages long, and there's 4 of them for whatever particular type of law you want to get into. So this is, the first one here is a big ask. And I don't know how we discuss this in a policy sense without seeing what those disclosures are, how tiny they're going to be, how they overlap with the informed consent requirement. So I guess how are we supposed to, and they're non-lawyers on our panel too, how are we supposed to really grapple with, is this more, is this less than what an attorney has to do?
Well, Carolyn, that's the easiest question you've asked, actually. It is exactly the same. So rule 1.7 for conflicts for current clients, whenever there's a conflict of interest that an attorney needs to either obtain informed consent from the client after appropriate disclosures, that would apply to paraprofessionals as well. That is the floor that we're talking about. And there are also conflicts of interest that are non-waivable under paragraph D of that rule, though that would also apply to paraprofessionals. So they need to go through the exact same conflict checking and obtaining client consent requirements that a lawyer would do. And this is what I will say, and it may not have been clear from my opening remarks, is I am not endorsing any of the recommendations of the regulatory subcommittee. All I'm doing is help facilitate their conversation around what policy decisions they need to make in order to stand up a rule of
I'll let
professional.
Steve go. I have so many questions. I'm glad that was an easy one.
I'm wondering though, would it be helpful if the red line of the proposed, the draft rules of paraprofessional conduct are provided as an attachment to the memo?
Steve, you're looking around.
So would it be helpful?
I'm ready to ask my question. Leia's talking.
Yes, would it be helpful to put up the red line rules? Because Carolyn's question, for example, is you can answer it if you actually look at the red line. So I'm wondering, maybe Steve, while you ask your question, we can try that. Linda, you could put up the red line. Go ahead, Steve.
Greg and Amos and Fariba, under the written agreement requirements, I would strongly urge you to consider recommending where there's hourly billing as opposed to flat fee billing, that paraprofessionals be required to bill in 1/10 of hour increments rather than 1/4 hour increments. This is a big source of tension between attorneys and clients. Steve Hamilton pointed out it's a matter of contract, and he's right about that. But the average consumer doesn't like getting charged for 15 minutes of time for an email that says, yeah, the mediation is September 2nd. That should be billed at a lower amount of time. And Greg, consistent with your comments, I believe that would be providing additional consumer protection and would be permissible.
Absolutely. It would be permissible to recommend that. I just want to finish what I was saying because I think it's an important point to that. I can't and will not endorse any subcommittee's recommendations because my role, I need to stay in my lane. My role is to ultimately present these recommendations to the court and make recommendations to them as well. And the court gets to decide, right? So, but what I do, the one time I can tell you that where I know there's unanimity on the court is that there will be no ethical standard that is relevant to paraprofessionals based on their scope of practice that will not apply to paraprofessionals as well. And as Steve said, there may be instances in which we recommend a higher bar, but so back to Carolyn's point, that everything that a lawyer needs to obtain in terms of informed consent around conflicts, and there's several conflict of interest rules within the rules of professional conduct, will apply to paraprofessionals at least. It may be even more that may be required of them. Okay, I hope that clarifies.
Okay, Kim?
I'm not sure how we're going to go through these, but I did have a question on the 1.4.2 on the mandatory disclosure and informed consent. And that was really, it talks about under A3, the risks of agreeing to obtain legal services. Are those risks going to be identified? Because risks is such a broad word that anybody can interpret that a little bit differently. So I don't know if we need to spell that out better, but I could choose a risk that somebody else might not ever see as a paraprofessional. So that was one thing. I didn't see it. Maybe I missed it in the write-up, but that was one issue that I have with just that section right there.
So let me respond because I think that's a very important comment, and thank you for making it. Yes, I think we have discussed and decided to recommend that the risks and alternatives be disclosed and discussed as part of informed consent, but exactly what that looks like, we still haven't worked through. And I think we're talking about maybe having standardized forms or recommended forms, because it might be difficult for paraprofessionals individually to do that. And it might be different in practice areas. The other thing we discussed is it really should be very clear up front before the decision to hire is made, what a paraprofessional can do and what a paraprofessional can't do. And again, we're limited because we're making these recommendations before the practice area recommendations. So our intent is to go back and maybe have ready for June more specifics about what this would look like. But the idea, again, here at the higher level is, this is our attempt that there is a recommended separate requirement of informed consent, as well as a written agreement with required disclosures.
And I want to add to that that we don't want this to be a document that basically says, "Oh, don't hire me. You know, it's a risk to hire me. Go hire an attorney." We definitely don't want to go that direction. We just want to give the client information, because information is power. What am I getting to? Who am I hiring? What powers do they have? And how they're different from hiring an attorney. We don't want it to be an advertisement for hiring attorneys. I think we've received enough public comment to that. I just don't think this should be that kind of a document.
And one thing I'll add also, and I'm actually channeling you, Randy, here, because there are instances in which we require lawyers to make certain disclosures and obtain, to make mandatory disclosures to their clients. And one instance that Randy had pointed to was mandatory fee arbitration. So to the extent there's a fee dispute with a client, lawyers are required to provide written notice that's already in a form that's been approved to their client, letting them know of their rights to pursue mandatory fee arbitration. So we pointed that out to the group because for that very reason, Kim, that we need to really identify what those risks are. I don't think it's probably difficult for every paraprofessional to know, especially early in a conversation, what the factual context is that the potential client brings with them, and to know what all the risks are, as well as like what are really their options. One of the disclosures here, I think, indicates that they may be able to obtain a lawyer. Well, that may or may not be true. They may be going to a paraprofessional because they can't find a lawyer. So I think we need to probably come up with some uniform language and provide a form, if we're going to make this a requirement for paraprofessionals, that they can use to provide prospective clients in the first conversation when they come to them for potential legal services.
And I think a comparison could be made to collaborative law attorneys in family law, where they have to disclose to their clients at the outset that they will not be going to trial. So the client knows, hey, I'm going to spend all this money on this attorney, and if we don't agree with the other side, then I have to hire another attorney to take me to trial. And this, I think that's a good comparison. So the client should know that a paraprofessional, for example, if that's what we decide, that the professional cannot represent me in court in this particular case type. So if this goes to trial, I'm going to have to hire an attorney or do it myself.
And I see that this is Yolanda, I see that there are some hands up. I would just, for purposes of the conversation, if we could get commentary about the rules, so that we're not jumping back and forth between rules, if we could kind of take one of these at a time, and Amos or Greg or Free, but whoever can lead us through that, that's fine. But I'd ask that we take one rule at a time with commentary about that rule before moving on to another one. Otherwise, I fear we're just going to spend a lot of time doing a lot of jumping back and forth. So since we're currently on rule 1.42, does anyone's, I don't know how to tell, if your hand is up and you have a commentary about this rule, then go ahead and speak.
I'll go ahead. So my question, it's not specifically in here, but it's this comment of putting a specific minimum time limit in, whether it's 0.1 or 0.25 on any specific tasks. Does anybody have an opinion about whether that would be constitutional or enforceable because it's breaching the contract. I know they do not have a comparable rule for attorneys, which is why Stephen became aware that some family law attorneys have a much different minimum. I commented at that meeting, mine's at 0.1 and I don't actually use it in most instances.
Are you talking about, Stephen, the suggestion that there be a requirement to bill at 10th of an hour increments?
Right.
Is that constitutional? That's your question.
Yeah, I'm questioning whether that's an unfair restraint on trade because that you're imposing a rule that won't exist for attorneys, and I don't know how you get around that you've got a different standard between attorneys and paraprofessionals.
Steve, there are all sorts of limitations on what people can charge. There's micro, there's workers' comp, there's
right.
I can tell you as a defense practitioner, someone who fills out timesheets every day, every single client insists on 0.1. I haven't been able to bill in quarter-hour increments in more than 20 years.
But that's because your clients are insisting on that as opposed to your being. I mean, I don't know how much time we want to spend on this right now. I don't know if Greg or someone else wishes to chime in on whether one could limit billing to say that it must be in the 6-minute increments.
I don't know if I could speak to the constitutional issue off the cuff, and I wouldn't hazard to do that. But what I would say, which I have said to the subcommittee on several occasions, again, we're talking about rules of discipline. And Steve Hamilton, you bring up a good point, which is if you're going to set a disciplinary standard, the next question should be how enforceable is it? And whether or not you want to spend the limited resources of the disciplinary system to enforce that. So normally how we enforce fees for attorneys is they must not be unconscionable or illegal. And if they are, and there's a set of standards under Rule 1.5 that should be considered, non-exclusive standards. And then if there's a dispute as to whether they're reasonable, we use the mandatory fee arbitration mechanism for resolving those disputes. So that's my only comment on that.
Yeah, and so the suggestions been made. I think the subgroup can take it under consideration. Does anyone else wish to be heard on this specific issue? And if not, let's move on. Ira, did you just raise your actual hand? Make sure you unmute yourself.
Yeah, my actual hand. I think we're on this subject. Where it says informed written consent at the top there, that is a term of art it's actually defined in one of the rules, and it's something that is different. Informed written consent is different in every situation in which it's given, and to include that term in this in what has to be in this mandatory disclosure makes it more, maybe too difficult, maybe not, for the paraprofessional to give what's required as far as disclosure. For instance, there would have to be different the way informed written consent means under the rules of professional conduct. It would have to be different in each different situation that the paraprofessional is embarking on with the client. Yeah,
Ira,
Go ahead, Dan.
Sorry, if I could just jump in. There was, and I think my comment's going to respond to what Ira's saying. There was a comment previously about subpart 3 and what the term risks means in that context. And for me, I thought subpart 3 was a little awkward in this context. And I think it could be responsive to Ira's concern if this is just a recommendation for Amos and Freba to take back, if they wish to consider removing subpart 3, because I think that concern is captured by the point Ira's raising, and that is depending on the representation that's being undertaken, the licensed paraprofessional will have to disclose as defined under the rules, disclose as part of obtaining the informed written consent, the material risks and adverse consequences to the representation. And that might change depending in any given scenario. And so if that's just a predicate requirement, I think of every licensed paraprofessional, I think you're capturing the concept of 3 and also protecting the client because you're informing them of maybe alternatives that the client could consider.
Well, may I add just one thought? If we're going to keep the phrase informed written consent in this rule, it can't really result in a form that paraprofessionals could use. They'd have to
Totally, I
add
would
a whole
agree.
lot.
Yeah.
Right. Right, and that's a really good point, Ira. Just so everyone knows that informed consent is defined under Rule 1.0.1E, and as Andrew also indicated, it really is it's incumbent upon the lawyer, and in this case, paraprofessional, to explain relevant circumstances and the material risk, including actual and reasonably foreseeable adverse consequences of a proposed course of conduct. So that you're right, and I think that does present a problem. I think what existing Rule 1.4.2 is a mandatory disclosure that a lawyer needs to make, that they don't have professional liability insurance. And actually, within that rule, we even provide the language that can be dropped into the agreement that will be presumptively compliant with that rule. So I think that is a very good point, that you may want to consider changing the rule to a mandatory disclosure rule rather than informed consent.
Carolyn, did you have commentary about this particular rule?
Yes, I have 4 questions.
Why don't we do one at a time so that the responders can track?
Okay. The first thing is just, this is a completely new rule. You're scrapping 1.4.2 and rewriting it as this one. Is that right?
Greg, you wish to respond?
The portion about professional liability insurance is new. The other portions, I think, Amos, you can speak better to that, because I think you brought this language, but I think it was based on rules that we saw in other jurisdictions, including Washington State's APR 28.
I think to answer your question, there is no similar informed consent requirement for attorneys that have to disclose that they're not attorneys and what the risks are in not hiring an attorney.
Okay, Carolyn, next question.
Well, I guess that begs the question. It's not, we're getting rid of the mandatory disclosure of insurance, so there is no requirement that a paraprofessional disclose that they don't have malpractice insurance. Is that right?
No, that's in the rule.
No.
If you slide down to the bottom of the rule, the existing rule 1.4.2 is embedded in this rule. Look at
We are adding an informed consent requirement. We are not reducing or eliminating any requirement.
You're adding to it.
Okay, so 1.4. I haven't had time to compare these, so you've moved, but okay, here's the problem, okay? You've put everything in together, but there's no way to compare. You've redlined it by totally rewriting it, right? It's, how do I know 1.4.2A is in there somewhere? Now it's under, if you scroll back up, it's, where is it? I don't see it in this 1.7.
It's right there. It's highlighted on the screen. That's being shared right now. Subdivision 7 talks about liability insurance.
Yes, and if you continue down, it is the remainder of that rule when you need to make the disclosure, when it's an ongoing requirement and there's exceptions. So for instance, when a lawyer is rendering legal services in an emergency to avoid foreseeable prejudice to the rights and interests of a client, that's from the lawyer rule as well as the final provision exception, or that it needs to be in writing. Yeah.
Okay, so you've basically rewritten 1.4.2 to add in subparagraphs 1 through 7. Is that, that's what
1 through 6, correct.
1 through 6. So again, subdivision 7 is what was there before, rewritten for paraprofessionals, with the remainder being the same. So it's what existed before with the addition of subdivisions 1 through 6 at the beginning.
Correct.
If you scroll back up, my next question is about the preamble. Okay, so this is prior to a prospective client's engagement. And Greg reminded me of the $1,000 limitation. So you can talk to a client and you can even give them advice and do something for them if it's under $1,000. Does that mean the prior to prospective client's engagement? When does that start? Does it start at $1,000, $500? Does it start when they think that
We
they're
are
giving
recommending that
professional
there be
advice?
we are recommending that there be no $1,000 precondition as there is for attorneys in the Business and Professions Code. So we're recommending prior to providing any services, they have to get informed consent.
And I want to
Does that
point out
even-
that that the $1,000 applies to the written agreement. This is a different document.
Yeah, this is the
So like,
disclosures.
go ahead, Greg, go ahead.
This is the mandatory disclosure. So this is a separate writing from the written agreement. The written agreement for lawyers, if you don't enter into a written agreement with a client when legal services are anticipated to be more than $1,000, that does not lead to discipline. What that leads to is the client at their own election can decide to void the contract. So that is not what we're doing with the written agreement part. So we're skipping ahead to the next rule. And I know that's not what Justice Petru wants to do, but
This will impact that. If there's a rule that will impact that,
we are making what is not a disciplinable violation by a lawyer disciplinable for paraprofessionals. As far as the written agreement part is concerned.
Yeah, okay. Next question is that how do we then take this, and this will be part of our task from today through June, to see what the licensing committee comes up with on how to train people on what informed consent and these these provisions are. Because I took the MPRE, and then I took then I read all the California rules. I think on the California bar exam it includes it could nab you on a written test on the California special.
So Carolyn, I want to make sure I'm understanding your question. Your question is a licensing question as far as how are people going to be educated about this?
Right.
Okay, well that's a legitimate question, but that's not a question for this group that's speaking right now, going over the rules. So we can discuss that when we're discussing licensing. And obviously any requirements are going to have, people are going to have to be trained, educated, and tested. So I think that's a given and we'll address it. But do you have any other questions regarding this specific subdivision? And if not, we need to move on to the fee sharing and non-attorney ownership issues.
Okay, yes, I do. It says provide certain written disclosures, and then it lists 1 through 7. So what other written disclosures are contemplated in that phrase?
So can I take that on? So this is sort of the discussion that we've just been having. I think my contemplation was specifically intended to be an informed consent requirement. So as discussed, that is different in different circumstances, might depend on the facts. We've been wrestling with wanting to do some sort of mandatory or recommended form so that it's easier to apply and so everyone's getting the same information. But there is some tension there because informed consent is fact specific. A form that, I mean, you could do a middle ground, a form with some fill-ins and things like that or samples, but we have not yet finalized what exactly the written disclosures will be because we have not yet decided what the meets and bounds of paraprofessional practice will be.
Okay, all right, I got it all on 1.4.2a.
Okay, so Amos or Fariba or Greg, which one would you like to discuss next? And just so the committee knows, I'm thinking that we'll continue this conversation. We'll give it about another half hour and then conclude on this topic area and break for lunch.
Okay.
I think 1.5.2 is the next because that is the written agreement and including mandatory disclosures that we talked about. So as was mentioned, for attorneys, there's no similar rule of professional conduct because it's included in statute. The written agreement is in Business and Professions Code 6147 and 6148. We did decide to recommend that there should be a written agreement with mandatory disclosures that track what attorneys are required, but also have some additional disclosures about the fact that they're not attorneys and what the fees will be. And so that is what is in the rule 1.5.2.
And one thing I'll add also, A1, 3, 4, and 9, near Business and Profession Code 6148 in terms of what is required for written agreements between attorneys and clients, and they anticipate the legal services will be over $1,000.
Okay, I can't.
Carolyn, go ahead.
Can you scroll back up because you flew through that? I'm gonna.
And everyone has this document as well. So if anyone wants to point us to a particular part of it that wants to be seen on screen, raise your hand and I can call on you, or someone can call on you.
Can you give me a minute to look at it? Or are we gonna?
We sent it around a week ago.
We sent it around last Wednesday. I was just saying, if you know there's some other section in this that you want to see or someone else wants to see, we can put it up on the screen.
While you're doing that, I could tell you, I've been looking at Utah, Arizona, and Washington. Utah requires a written agreement that includes elements set forth in this rule, including purpose of the hire, services to be performed, rates and fees for services, and responsibility for costs. They require it be in a 12-point font. It also includes a provision about where to report complaints, what documents will be prepared. There's a number of requirements in their rule as well. And if it's non-compliant under their rule, it's void as well. So it's a disciplinable offense and it can be voided. I think in California, what we would probably do is want to amend 6148 so that it's consistent with the statute for lawyers to make it voidable.
Can I recommend, Linda, can you please try to make it a 100% view rather than 153% so that we can see more on the screen at the same time?
Arizona has the same rule that applies for lawyers. They have to enter into a written agreement, include the scope of representation, the basis and rate for fees. They have to be communicated in writing before or within a reasonable time after commencing representation. And also Washington has a written agreement requirement as well with similar requirement elements that need to be met.
Yeah, and I'll also note that we did look at the other state rules, as Greg points out. We also looked at other things like immigration consultants has a rule that requires certain disclosures. And other, so we didn't make this up. We were tracking other rules and of course using common sense about what types of mandatory disclosures would be important in this context for protection of the public and to make sure people are able to make informed decisions.
And one other thing I'll add is that there are of those 3 states, no other state requires both a pre-engagement mandatory set of disclosures as well as a written agreement with. This is a higher bar than any of those 3.
Greg, if you can just, I just had a request from a working group member. Very quickly, give a primer on how to read these rules revisions, just in terms of if it's in black text, it's the original existing attorney rule. If it's in red, what that means. Just quickly, thanks.
Sure. Well, 1.5.2 is all in red because there is no rule like this for attorneys. So we are adding it into the rule of professional conduct for paraprofessionals, something that does not exist. There is no rule 1.5.2 for lawyers. If it's red, it means it's text that's been added. If it's struck through, we are removing or deleting text that is in the rule for lawyers. And if it's in black text, it is the text from the lawyer rule.
And in this rule, for example, is there any significance to some things being highlighted or not?
The one thing that's highlighted here is the statement that the paraprofessional has a surety bond as required. And it's highlighted because I imagine that's going to be a rule of court requirement that they carry a surety bond. And we are going to have a cross-reference to that rule of court, but we don't know what that rule of court is at this point. So that's highlighted. I don't know why paraprofessional. Oh, I think paraprofessional is highlighted before where it says rules of professional conduct, and paraprofessional board as well, because we don't know what the name.
Well, I'm looking at the screen that Linda has up right now that we are all looking at.
Oh, I see. Okay. That's a comment from me. And that comment says, because this particular statement, this was to the subcommittee group. That particular.
Okay, so but just so, I don't think we need to get into what your comment was. I just think we need to understand what is up on the screen right now that everyone is looking at. The fact that some of this appears to be highlighted, the highlighting should be ignored. It's irrelevant. Is that correct?
Yes.
Okay, so the bottom line is red is new, black is old, and struck through obviously is to remove.
Mm-hmm.
Okay.
Ira, is your hand up about the written agreement?
Yes.
Okay, go ahead.
Number 10, which is not on the screen, but I've got it open on my other screen. Is that meant, does that mean that all the disclosures in the previous rule we looked at are required to be in the agreement too?
Any other disclosure statements or conditions required by the paraprofessional rules of professional conduct and the rules and regulations of the paraprofessional board? I don't think, Amos, I don't know if that was your intention, including that they have to disclose everything they've already disclosed.
No, so this came about because, as was mentioned prior on this call, there are a number of other disclosure requirements or informed consent requirements that are required of attorneys and will also be required of paraprofessionals. For example, if there's a conflict situation or a fee sharing situation or something like that. So this is, what this means is this is not the exclusive list. If there's some other disclosure requirement that already exists for attorneys and it's going to exist for paraprofessionals, it doesn't mean they don't have to make those disclosures as well.
Well, how about saying in number 10 that at the end, other than the disclosures in 1.4.2, so they don't have to repeat the whole thing?
Yeah, I think we can make it clear. These are two separate requirements. So to the extent there's confusion because there are two separate requirements, I think it makes sense to clarify maybe in a comment.
Anyone else on just this rule? Carolyn?
Is this the only time we're going to be having discussion in a working group on these rules? Because if we're talking about
No, I
policy-
mean, Leah already went. Leah, if you could chime back in, but I think you addressed this already.
No, this is just a discussion and then the rules are going to come back to you for a vote in June.
Right, but we're
and
not
discussion in June.
Right, discussion and a vote in June, and between now and then you can always send comments into the regulation subcommittee, and of course they're going to be meeting between now and June. Also participate in those meetings as you see fit.
Okay, but no other discussion except for what we get in June, which would be part of the stuff that we discuss in June. I'm just trying to figure out how much I should comment because I'm an attorney. I've, lived by these rules my whole entire life, and I have a lot of comments. So I don't want to take up all the committee's time, but I wish in May we would have a chance to go over some of these again in public.
We will be having a regulation subcommittee.
Amos, yeah, let me just say, speaking of in public, all the subcommittee meetings, of course, are also public and people are very welcome to participate in those. This group will be meeting.
Yeah, and I invite you to come and comment. We would love to have your feedback on the proposed rules. And we have been working very hard on them, and we'll continue to meet to try to incorporate any comments.
Okay, I don't want to get so nitpicky as to waste everybody's time, so
okay,
put my hands
up. So I don't see any other hands, and so do you want to move on to your next one that you'd like to get feedback on?
Yeah, Greg, do you have a recommendation?
Yeah, the next was on the representation of organizations according to the slide. So under Rule 113, a lawyer is instructed to conform when they represent an organization, conform their conduct to the concept that they are representing the organization, acting through duly authorized representatives. And it also provides an ethical roadmap for lawyers if they reasonably believe a constituent of the organization is engaging in unlawful activity. So it's an important rule that obviously raises the question that I raised to the regulation subcommittee, whether or not paraprofessionals should be permitted to represent organizations. Washington and Utah, they prohibit representation of organizations. Arizona applies the same rules for lawyers, meaning they can represent organizations. So Arizona follows a lawyer rule. Utah and Washington have a higher standard. And this group has decided to follow Washington.
So what feedback, if any, so Greg or anyone, Amos or Fariba, what feedback specifically are you asking for, if any, from the group on this?
So the policy level decision that we are recommending is that paraprofessionals not be authorized to represent organizations. So if there's concerns or feedback or comment on that, because that makes the rules drafting easy. If we have a different recommendation at a policy level, that's what we need to consider.
Okay, so if anyone wishes to be heard who thinks that paraprofessionals should be allowed to represent corporations, pop your hand up.
And just to be clear, any organization, so nonprofits, associations.
Right. Thank you. Kimberly?
Just a quick question. When the justice gap and all that was done, was it really done just for individual clients on everything that was reviewed and surveyed? I can't imagine an organization not being able to seek legal counsel, but now that you're talking about it being like nonprofits and those kind of entities, that's a little bit different.
That's right. The justice gap only surveyed individuals.
And I think, mom and pop businesses are included in the definition of organizations. They're businesses. So there may be some access to justice issues, but again, this hasn't been studied or anything.
Right, that's right. You heard a public comment to that effect earlier today.
Right. And I do think that's the area where it's more likely to come up, is in the housing and unlawful detainer area, with the concern of, individuals who, let's say, rent out a room in their house or a couple of rooms, or have just one or two properties. So that's where I've heard it coming up. Okay, I don't see any other hands. Can you move on to your next topic?
Sure,
Ira's hand is up.
Oh, sorry.
Just one comment. It seems to me that a paraprofessional would be able to represent somebody who owned a business, if it's just an individual who owns the business, even if they own the business with their spouse. If I'm wrong, I'd like to hear.
Well, I'd like to understand what you mean, Ira, because my understanding, if we remove this, is that nothing could be filed on behalf of the business. And so the paraprofessional could represent the individual in his or her individual capacity, but not represent the business per se. Greg or someone, am I getting that wrong?
I don't think that's right. What if it's a sole proprietorship? The business is not an entity that can appear in court. The person is the owner.
If they're representing the person as a sole proprietor, I guess the only other question would be whether or not the services that are being provided are within the authorized scope of practice.
And keep in mind the specializations that are being authorized in this whole program.
Stephen?
Yeah, Greg, where do DBAs fit into this? I understand a DBA is not a separate legal entity and is effectively whatever the underlying entity is, if it's a person or a corporation. So would an individual with a DBA fall under this or not fall under this?
Well, if it's not an organization and they're DBA and they're being represented in their individual capacity, it really will boil down to how we end up writing the rule. I imagine this would be as opposed to a rule of professional conduct, this policy decision will be reflected in a rule of court defining the scope of permissible practice for paraprofessionals. And so to the extent we're saying that paraprofessionals can only represent natural persons, they would need to fit that definition. And again, I mean, I don't know if this is the biggest issue we should be dealing with, because I would see as probably the larger hurdle that they would have to scale is that it would have to be within the legal services that the paraprofessional is licensed to provide.
And on that note, I will say we don't have to go through these numerically. I'd encourage you to like move to whatever the ones are that you think are most useful to get feedback from. Judge Rubin, your hand was up before, but I don't think it's up now. Do you wish to be heard?
I have been in situations, I guess I was just asking for clarification or someone to round out the thought. I've been in situations where I've had a person represented in a labor situation where the person is represented, the employer, but the corporation is not represented. It created lots of trouble and problems. And I'm just curious, do I understand that because of the limitations on representation in the labor area, this is not going to be an issue, or in other areas where it may come up, it's too minor or too rare for us to be about which to be concerned?
So let me try to address that. I think we're not solving all issues with this proposal. So there are going to be areas where the paraprofessional program doesn't solve the problem. I think in certain practice areas, there's been some specific discussion like debtor versus creditor representation and things like that. I think the housing, right now, that does not distinguish between if they're the plaintiff or the defendant, but there's been some commentary about that. So I think each practice area is going to need to do that. But this is more of an overview of the whole program policy decision that really the paraprofessional program is designed at this point to be filling the justice gap for individual litigants that can't afford an attorney, and allowing organizational representation, opens up a lot of other areas that haven't been studied and we haven't really addressed yet. So we're really recommending following the Washington state model, which is at least at this point, focusing on a representation of individuals.
And I think that's like a fair comment. Like, one, there's going to be some minor gaps here and there. I don't mean minor in terms of importance, but minor in terms of the size of the issues. And two, this is probably not a static event, and that there's going to be some evolution of this over the years if it comes to pass at all. So thank you.
Right, thank you.
Okay, so Amos, Fariba, Greg, what would you like to get feedback on next?
I want to leave it to the subcommittee. Next on the list is contingency fees, and I know that probably will generate some discussion, but there are some other thornier issues down the list. So Amos and Fariba, what would you like to get feedback on?
We could just go forward with contingency fees unless Amos has a problem with that.
If I could just step in, because we only have 15 more minutes, and I do think it's really important to get to fee sharing and non-attorney ownership. Maybe we also want to get to contingency fees, and Steve has his hand up. So I just want to do that quick time check and say that I think the most controversial proposals are those two, and we need to make sure to get to them.
I suggest we do that too. Just very quickly, contingency fees, we originally were prohibiting them and then got convinced that maybe in the enforcement of judgment context with a cap is going to be our recommendation. But Greg, do you mind sort of leading the discussion on the relationship between paraprofessionals and other paraprofessionals and between paraprofessionals and attorneys?
Sure. So one of the questions.
So first of all, can we get let Linda know what she should be putting up on the screen right now?
Sure. We might as well go right to 5.4, because if we're talking about co-ownership of law firms, that's where we would need to be. So
all right, thank you.
One of the policy issues, obviously a big one, is how paraprofessionals will be permitted to interact with each other in terms of combining into law firms, and of course, combining with lawyers as well. And whether or not paraprofessionals should be, if they are working with lawyers, should they be not only co-owning, sharing fees, and also the supervision rules around whether or not they should be limited from supervising lawyers should they be required to report to a lawyer? So the paraprofessional group the regulatory subcommittee has recommended that paraprofessionals be permitted to combine into law firms together, and that means we will have a set of rules around supervising subordinates. That's 5.1 through 5.3. It also affects obviously 5.4, and it will affect Rule 1.17, which provides another ethical roadmap for lawyers now, but for paraprofessionals in this instance, if they seek to sell or transfer their stake in a law practice, so to protect the public, essentially. But 5.4 is where I think a lot of this discussion is going to be generated, so we can discuss that. As background, paraprofessionals are allowed to combine into law firms with each other in Arizona, Washington, and Utah. That's allowed in all of those states. In Washington, they are allowed to combine with lawyers in the same law firm and have an ownership stake as long as it's not a majority stake. And then in Utah, they can fee split among each other with lawyers, but they cannot own a law firm unless they enter the regulatory sandbox. So I think Professor Moore alluded to that earlier in the conversation. Arizona is the most liberal. They allow fee splitting, and again, they do not allow true referral fees. That's a different thing. So they apply the same rules that they apply to lawyers to their paralegals. And so they are allowed to combine and have ownership stake in firms, and there is no limitation on their the amount of the shares or the ownership makeup of those firms for paraprofessionals. So that's the background that I provided them, and I'll let Amos and Fariba talk about their recommendations.
Yeah, this is another place where I think it might help to at least start on a high level as opposed to redlining of the rules, because I think these policy decisions are important in shaping what the rules are. So our general recommendation is to follow the same rules as for attorneys, to allow paraprofessionals to practice with each other, to allow paraprofessionals to practice with attorneys, to combine, with the limitation following the Washington state model that a paraprofessional would not be able to own a majority stake in a combined firm.
All right, Steve.
Yeah, I'm opposed, well, 2 points. I'm opposed to all the fee sharing and referral fees as it relates to attorneys. I've got no problems with paraprofessionals partnering up and giving referral fees to each other at that level. But one thing that just jumped out at me is, why in the world are we allowing a paraprofessional to take a 49% ownership interest in an immigration law firm or a personal injury law firm or any one of the 150 other areas of law that paraprofessionals are not allowed to practice in as paraprofessionals? That just makes no sense to me. I don't know if that was an oversight. I don't know if that was a deliberate decision, but why don't we start with that, and then I'll go to my other comments.
I thought every decision we make only apply to the areas of practice that we're authorizing under this program. So how are we jumping to immigration and everything else? Do you mean, Steve, that we need to write it out, or?
The revisions I read to 5.4F is that you're allowed to own up to 49% of a firm.
But within the areas of practice that are being authorized under this new program. Gregory, am I misunderstanding that? Am I misstating that?
Well, I don't think the intention of this group was to allow paraprofessionals to own a 49% stake in a law firm in which they cannot practice law. I don't think that was your intention as a subcommittee. To the extent that you're interpreting that rule to allow that, I think we should go back and make sure that it's written in a way that it's clear.
Exactly. If I could just, Greg, if I could just jump in, I don't think you're going to hear a whole lot of disagreement with Steve Fleischman's point on this in this group. And so I think this is a point to be taken back for editing purposes to make it clear.
Yeah, I agree.
Okay, but then just to follow up on that, Justice Petro, and thank you. Law firms, practice in lots of different areas. And so, you may have a 12-person firm and 2 people do family law, and it may be appropriate for the paraprofessional in that context, but they shouldn't be sharing.
No, I totally get, I mean, I completely understand what you're saying, and it may be that it winds up being basically impossible for this to work. But I'm just asking at this point that this subcommittee take your comment back with an eye towards ensuring that we are not somehow allowing paraprofessionals to have an ownership interest or do fee sharing in circumstances that it's an area of practice for which they're not authorized.
All right, then my second point is, my view is we're making this too complicated. Paraprofessionals will be in one of two categories, either certified paralegals or people that have JD degrees and have not, for whatever reason, passed the bar. Both categories are able to work in law firms under the supervision of attorneys, and there are existing rules governing how they can be paid and can't be paid. It seems to me those same rules should apply, and the only thing a paraprofessional will be able to do differently under this program are limited court appearances in a small number of areas. And that small change in status does not, to me, seem to justify sharing fees or changing the status quo. On the other hand, if the paraprofessional has the entrepreneurial spirit and wants to set up their own firm, God bless them. I admire people with entrepreneurial spirit. They should get to keep 100% of their fees, but we shouldn't be mixing between the two professions for lots of historical reasons, all of which are designed for consumer protection. And, you know, same thing for referral fees. As I read the revisions, it would allow referrals fee for immigration, PI cases, lots of things outside of the scope. So that's where I'm coming from. And I'd really ask the subcommittee to go back and think about the limited nature of the paraprofessionals and how this could work. But I'm just in favor of keeping the two separate and no fee sharing, no referral fees. That's my, thank you.
And I think that's a position clearly and well stated. Ira?
I appreciate Steve's point here. It would be nice to make it simpler, but there's one thing that I think he said that I think interferes with that, which is he was saying that there are rules for paralegals working in law firms about how they can work and fees they can get and can't get. And there's working supervised by lawyers. But I thought Steve was saying that the same rules could easily apply to paraprofessionals working in law firms. But the big difference is that the way we're conceiving paraprofessionals, even if they're in a law firm, they do not have to work under the supervision of a lawyer. That's one comment. And just one question. I think this is true under anyway, under one of these subdivisions, that nobody but a lawyer or a licensed paraprofessional can have an ownership interest or control or be an officer, et cetera, in a firm employing paraprofessionals. Is that true, that last thing I just said?
Yes.
Okay.
So before we go on, I just wonder if Kevin or Greg would speak to the rationale for why referral fees in particular, because I think there is a public protection argument to be made, or why we have it in place, you know, on the attorney side. So could someone just talk to why we might allow referral fees?
To speak quickly to that is, with lawyers, there's an issue of encouraging lawyers, if they don't have the expertise to handle a particular case, to refer the matter to another lawyer who does have the expertise. Within a large law firm, you would refer the matter within your law firm to another lawyer who might specialize in that area. But where you have a solo practitioner or someone in a small firm where they don't have that expertise, it wants to be encouraged. This has been, California courts have actually encouraged this. This is actually goes against the majority of jurisdictions in the country, where the position is, well, you can't represent someone if your representation is going to be incompetent. So you shouldn't be rewarded for simply complying with the rules and referring a matter out. But California has taken this position, and perhaps Randy or Andrew can remind me how long it's been, but it's been about 70 or 80 years, I think, since the decision came down that encouraged lawyers. And, you know, the courts have no problem with referral fees. And I guess the question here is, will there be a sufficient number of areas where you might want to encourage paraprofessionals to refer a matter to a lawyer? Well, yes, it's outside their area of expertise. They can't handle the matter anyway, whereas lawyers can educate themselves or acquire the necessary skills or knowledge to take a case. So that might be an issue that you might want to address, but is there any harm in providing that encouragement to facilitate the referral to a qualified, competent lawyer and provide some kind of a reward, and whether you would put a cap, excuse me, a cap on what type of fee might be allowed, that would be, I suppose, another fertile ground for debate.
Let me just mention that on page 10 of the subcommittee's memorandum, this issue is specifically addressed, and as Kevin was mentioning, it goes back a long time. And for the lawyers, there's a case called Moran versus Harris, a 1982 case that is cited on that portion of the subcommittee memo. So if you're digging deep, that's where to look.
Yeah.
All right. Cool.
Only thing
Go
I
ahead.
will add is it is a longstanding public policy in California. There was a period in the 70s where we followed the majority of jurisdictions, and then we went back, I think. So it's a longstanding, but there only a minority of jurisdictions follow this pure referral fee. There's 12 of them, I think, from last count, including California. None of them include Utah, Arizona, or Washington. And I think that Professor Moore makes a good point. One of the reasons we allow true referral fees is because it's to really encourage conscientious but less experienced lawyers who may not, the matter may be more complex than their training or their level of competency, to get that matter to the best lawyer and receive some compensation in return. That's less of an incentive with the paraprofessional group because they have a limited scope. So to the extent it goes beyond their level of competency, they need to refer out. And if you were to follow the majority of jurisdictions, it would still allow for reciprocal referral fees. It's just that consideration would not be exchanged for that.
Yeah. Greg, I have a slightly different understanding of the states that don't allow pure referral fees. My understanding is the vast majority of states follow the ABA rule on that. And the issue is you can make a referral, but you have to maintain whatever percentage you're getting as a referral. You have to stay on the hook for that percentage of liability. So it's kind of a put up or shut up type of scenario where, yes, you can refer the case, but you're going to stay on and you're going to remain liable to the client in relative percentage. And yes, I suppose if you really truly were incompetent and couldn't take, or it wasn't in your bailiwick and you really couldn't be involved in it, under those states, you'd have to get out. But I think in practice, the ERISA lawyer with a personal injury case refers it to a personal injury attorney and lets the personal injury attorney run the case, and they get their referral fee that way. That model doesn't work with what we're talking about for paraprofessionals for a lot of reasons.
Right.
Okay, I'm gonna actually jump in here. I'd like to hear from Julia, and then we're gonna take our break, and then we'll come back and talk a little bit more. Julia?
Yeah, the only thing I wanted to mention was, I guess I have a concern about referral fees as well. And I'm just thinking about, for example, the workers' comp practice where there was a lot of problems between workers' comp attorneys and chiropractors and getting referrals that way. And in order to reform the system, they required that certain documents be signed that no one had received a referral fee for someone being sent to an office. So it became so problematic that there was an entire system created in the workers' comp world to address some of this referring. And I guess that's just the kind of scenario I'm concerned about, is that perhaps you don't want to be a person who just is taking in cases to generate referral fees to kick them out to other folks. So I was thinking also within the work comp environment to consider, you know, if you're a prior lawyer in one of those cases and the client subs you out, you can file a lien in that case. And that way, when the attorney's fees are awarded, the split of attorney's fees has to be negotiated and things like that. So I think there are some guardrails that maybe this group could consider in terms of making sure that there's not a real problem established in terms of people using this in a cyclical way just to generate income. That's all I wanted to say.
Thank you, Julia. Okay, it's 1:03. We're going to break till 1:35. We'll come back and talk about this somewhat more, although not a long time more, because we do need to move into our subject matter areas. But let's break. Okay, see you all at 1:35. Hey, Julia, did you want to have your hand up now, or was it a remnant from before?
I think it's a remnant from before. I don't know that I made my point as clearly as I would have liked, but anyway, that's all right.
Okay.
Your point was very good, Julia.
Thank you.
It was very clear.
It was.
It's better when we're clearer outside of our heads and as compared to inside our heads.
Yeah.
Linda, are you back?
Yes, I am.
Okay, great. All right, so it looks like the gang's all here. If we could hear from Carolyn and then Stephen, please.
Oh, you know what? Hang on.
Take your time.
Oh, I can't get the video started for some reason. Oh, there we are.
And we are
No?
still on referral fees, correct? Just
Yes.
Okay.
Oh, okay. So on that, and this, I'm just going to keep this really quick, and it might be a comment, it might not. I noticed in the definitions, it struck me that it talks about legal services, and so we kind of jumped over what that means in terms of we keep talking about the practice of law and legal services. So we sort of jumped over 1.0, I think it is 1.1, the definition of unlicensed practice of law, and I think the suggestion was going to be it was the unlicensed practice of paraprofessional services. So when we say legal services in this, shouldn't it say paraprofessional?
Can we get to the right? I just want to make sure I'm looking at the right thing here. What section should I be looking at?
I think I heard Greg talking about it. There is a definition of the practice of law somewhere. There is a unlicensed practice of law section, and I thought that this is just to talk about.
Maybe Greg can help point us to the right section. So, because I'd like to be looking at it while you're talking.
I think it's rule 5.5 that is the UPL rule. There's not a definition of the practice of law, though. That's actually the Rules Revision Commission purposely decided not to follow the minority of jurisdictions that actually do define the practice of law in the rules in their rules of professional conduct. So we rely on case law, most notably the Burbauer decision by our court.
Okay, so when it says admitted to practice law shall not, that goes by the definition of law and case law. So they will be by negative.
I'm sorry to interrupt. I want to make sure that I'm tracking, Carolyn. I just want to make sure that I want to make sure I understand your comment correctly, which is why I need to make sure I understand the context in my own head first. So Greg, correct me here. This rule 5.5 is saying licensed paraprofessionals shall not practice law beyond the permissible scope of their license. In other words, is the point that they're limited to the designated areas. Is that correct?
That's correct.
Okay, sorry to interrupt, Carolyn. Go ahead.
Okay. Yeah, so the question is, with all this terminology, they are being admitted to practice law.
Paraprofessionals?
Right.
Yes, absolutely. Within a limited scope as will be defined by the individual practice groups.
Thank you. Got it.
And could we haven't had a chance to hear from Elizabeth. So Stephen, I'm going to ask you to hold for a moment and so we can hear from Elizabeth.
Hi, everyone. So my question is about not necessarily the referral fees, but going back to the regarding having paraprofessionals have ownership. So if Stephen Fleischman's was about referrals, then I would let him speak first.
Elizabeth, why don't you just go ahead?
Okay. So my question is, we are going to be allowing that paraprofessionals to have ownership with the attorneys as long as it's not a majority interest. Is that correct?
That's the recommendation, yes.
Okay, perfect. I just didn't really understand Stephen Fleischman's comment regarding why are we talking about this in this meeting. I might have misunderstood, but I just wanted to use this time to just remind everyone that it's because it's inevitable that the paraprofessionals will most likely be hired by attorneys because they're already doing it. The Washington LLTs are doing it. They can practice solo or within a law firm. But the reason why I see it being a big issue in California is because the paraprofessionals will be able to give legal advice. They'll be able to advise their clients on the appropriate legal procedures and then draft the legal forms. And they are cheaper than, they may be cheaper than an associate. And also they can, like Ira mentioned, they can operate without attorney supervision. And also some law firms will find it lucrative if the LLT is in-house, and they will probably feel like there will be referrals for more complicated work that the paraprofessionals won't be able to handle in-house. I just wanted to mention that during this meeting. Thank you.
Thank you, Elizabeth. Stephen?
Yeah, I was just going to say I agreed with Julia's comments just before the lunch break. We're going through and making this whole program. It shouldn't be just for the purpose of allowing people to generate referral fees. I just wanted to leave it at that.
All right, thank you.
If I could come in and just ask a clarification on Julia's comments. Were you saying, Julia, that you don't support allowing referral fees at all? Or what I heard you say is that you would recommend that there be some kind of guardrails put on the effort. For example, a paraprofessional might be required to disclose all of the referral fees that they received, and there could be some regulatory oversight of that. So could you clarify?
Yeah, I mean, that's what I was contemplating. It was more of an idea of just saying, can they or can't they? I think if we come to the point that as a majority, we're going to say they should be able to engage in referrals and receive a referral fee, then perhaps what I'm saying is, I just, having been a part of different industries, seeing where things have gone awry, I do think there's got to be some guardrails to that, because it sounds very enticing to folks who maybe, you know, so are we saying they can refer even outside of their area expertise and get paid for it? So I guess those are the kind of things, because then it sounds to me like a runner or capper. I'm not sure, but I guess what I'm saying is I really hope that the subcommittee contemplates guardrails for an abuse of that system, and maybe they should be limited to amounts or percentages or whatever, because we do have the percentage limitation in workers' comp, things like that. So I think we have to be cautious and have some guardrails. I don't know if it's a cap on how much, disclosing how many they get. You know, if they disclose it, what happens to them if we find out that they're getting 30 a month from one attorney? I mean,
right.
So what? Why are they disclosing it? See what I mean? I think all of those ideas are helpful, but to what end?
Great, got it. Thank you.
And because you also, can I just respond to that, just so you understand the guardrails that are in place for attorneys? Because in order to understand this area, you actually, you mentioned the runners and cappers, that's Business and Professions Code 6152, is one provision that needs to be considered, as well as 3 separate rules of professional conduct. So the Business and Profession Codes prohibits anyone acting as a runner and capper for an attorney. And also it makes it a crime, actually. And also for an attorney to solicit anyone to act as a runner and capper for them. One exception is under subdivision C, that it does not prevent a recommendation of professional employment for an attorney that's not prohibited by the rules of professional conduct. So that's where the 3 rules come into play. And Rule 7.2 prohibits a lawyer from receiving any compensation from another person, including another lawyer, for recommending or securing the referral of business, so long as it doesn't violate any other rule that State Bar Act. But that doesn't prevent reciprocal referral agreements between other professionals, so a chiropractor perhaps, and a lawyer. It has to be non-reciprocal, which means not exclusive. The client has to be informed of the existence and nature of the agreement. And I think what you identified, Julia, in the workers' comp area was a loophole that some lawyers perhaps were exploiting, because 7.2b5 allows the lawyer to provide a gratuity or gift for anyone providing a referral, as long as there was no promise or agreement that it would be forthcoming. And it's not an encouragement that such referrals happen in the future. So that may be an instance in which a lawyer was actually violating, if it became a consistent thing and it was exclusive, was violating an existing rule, but it was difficult to enforce that rule because nobody was complaining to the State Bar about it. So that's the only point I would make about that.
And Stephen? Oh, sorry.
Well, I was just going to say, the other thing is, you know, I too am a little concerned with having a paraprofessional be a 49% owner of a firm that, I mean, I think what Steve Fleshman said before, I believe it was Steve, that really we should be looking at how can a paraprofessional own part of a firm if they're doing a multitude of areas of law. that are in excess of what the paraprofessional is certified for. So if they have one endorsement, I think we've got to be very cautious additionally over what kind of ownership they could have in a firm over attorneys that are maybe not partners, but they somehow get to influence. I just, the little bit of the former legal malpractice attorney in me is the antennas going up, and I'm just seeing issues. And I just hope that we're attempting to have this in the most sound way we can. By yes, we want them to feel comfortable and to share the work, be responsible about referring it to someone who's a more appropriate legal professional. But I also just question the ownership and things like that, because I guess I hadn't really considered that until today, and it bothers me a little bit. But thank you.
Thank you. Stephen?
Yeah, Greg, going back to the runner and capper issue, as I understand it, the phrase runner and capper is just this ancient phrase that for some reason got stuck into the B&P code. But my understanding is anybody other than an attorney can be a runner and a capper. So currently a paralegal could be a runner or a capper and doing that illegally. Do I have that right?
Yes, that's correct. Anyone could be a runner and capper.
All right.
Okay, any other comments, or Amos and Fariba, any other very focused things you want feedback on before we move into substantive areas?
Do we want to hear about non-attorney ownership explicitly and contingency fees? Those are the only.
Well, I think we've been talking quite a bit about non-attorney ownership, unless, I mean, I think we've had quite a bit of discussion about that. If we want to hear more about that, we can. Contingency, what would the subcommittee like to do?
So on contingency fee, we started with the recommendation of a prohibition of contingency fees, but then it was addressed that if enforcement of judgment is a practice area that is allowed, that is a practice area that often works on a contingency fee and might be an access to justice issue, where as a litigant or former litigant may not have the means to hire somebody on an hourly or flat fee, but might be able to have access to legal services if a contingency fee was allowed. So our current recommendation is to prohibit contingency fees with the exception of the enforcement of judgment area and subject to a cap.
Anyone wish to be heard on that? Ira?
Yeah, pardon me if I should have read the rationale already, but what is the rationale for not allowing contingency fees for paraprofessionals?
In any particular area that you have in mind, Ira?
Yeah, well, no, actually, I don't have one in mind. Maybe I should try and identify one, but if,
it might help, but I'm happy to try to address your question, but I think we were going practice area by practice area. So my understanding is in family law, contingency fees are already prohibited.
Yeah.
And there's public policy behind that. So we were really looking at the other practice areas and tasks that were under consideration. And enforcement of judgment is the one area where it jumped out that said, yeah, it might be appropriate there. But otherwise, we were concerned about the potential for abuse and fees getting excessive. And again, this being intended to be a lower cost alternative to engaging a lawyer. So those are the considerations that went in. And I think it really was the enforcement of judgment practice area that we really did see there might be an access to justice issue with wanting to allow that, but didn't see that concern in other practice areas where if a contingency is available and an attorney is available, that might be a consideration why paraprofessional, they would be able to compete, if you will, or be available as a lower cost alternative on a flat fee or an hourly fee.
well, all right, then I'd like to speak against the prohibition of contingency fees. Some of these points, I guess, will be obvious, but if we want to enable people to get representation that they otherwise couldn't get, sometimes they can't come up with cash. But a contingency fee.
Ira, do you mind addressing it to specific practice areas? Because I think that's right generally and theoretically.
All right. Okay.
It would
Okay.
be helpful to address the specific practice areas and tasks that we're considering.
All right. Employment. We're allowing wage and hour claims in limited jurisdiction. So that if somebody can't come up with fees with cash to pay for a paraprofessional to do that, this enables them to do it. What other areas? I can't remember right now, but anyway, so that's one example. And if I agree that there should be, there's a concern for excessive fees, so we can put a cap on them. 25% even is used to be a common contingency fee in tort cases, not anymore. I don't see any, except for keeping the fees down so they're not excessive. I can't see any reason, any policy that it serves to prohibit contingency fees. Is there one other than keeping the fees down? I don't think so. And we can
Stephen
keep the fees
Hamilton.
down another way.
All right, thank you, Ira. Stephen Hamilton?
I just want to confirm what Amos said. We do not allow, for public policy reasons, contingency fees in family law matters are prohibited.
Right. Right. Carolyn?
Perhaps it's no surprise, but I adhere to something called the American rule. And, that's something we have in America that we don't have in England and other common law areas. My question is then, why a cap? And if you're going to have a cap, what's the amount of the cap? And how do we figure that out?
So I'm sorry, I'm not clear on what is your position. The subcommittee's recommendation was to not allow contingency fees. What is your position on that?
Well, I want to know what it is all about. Why are we talking about this? Is there going to be a cap, or are we going to go with the American rule? Before I take
Which is what? Just so we're all speaking the same language. When you say the American rule, what is that?
In America, we allow for contingency fees, and we allow people to, you can get costs and fees. There are all kinds of things. And Steve's going to correct me because I'm saying it all wrong. My question is this: why cap? And what is the amount going to be? Because if it's 5%, I might be against it. If it's 100%, I might be for it. I don't know. When we just say we'll have a cap, we're not going to have a cap, there's no way to know how to vote on that.
Well, but there's no cap here because the recommendation is to not allow it, period, full stop.
No, Justice Petru, it's to allow.
To allow it, sorry.
Only
but with that
judgment cases with a cap.
Right. Yeah. Right.
With a cap. Why a cap?
It's a consumer protection issue, and today we're not voting on anything, so we would love to hear your comments. So we don't have a position on what's the cap. We'd like to hear about it. Carolyn, do you have a proposal other than the American rule, no cap, free enterprise? I'm assuming that's what you're talking about.
I think that's pretty self-explanatory. I mean, there's all kinds of reasons why, and I think some people on ATIL said, well, this isn't about competition. This is about expanding the pool of availability for consumers. So this isn't about people coming and competing with people in the judgment debtor arena, but this could be this is a huge signal, and this is going to create a lot of discussion all over the map. And so if we're going to talk about caps on fees, there seems to be in California never caps on fees in contingency cases, never. And it's not just personal injury. In patent law cases, trademark cases, contingency fees have become a real thing. And so it's not just limited to personal injury cases. A contingency fee is a business device to make a case attractive to people. So if we're going to have caps to protect the consumer, I don't understand that at all. And so someone has to explain to me why a contingency fee is bad for consumers.
And I wonder if this is a discussion best kept for our group meeting on fee caps, Justice Petra.
Yeah, no, I think so, but I think an important point's been
Yeah,
raised for
absolutely.
the subgroup to go back on.
Yeah, thank you, Carol. We'll take notes and discuss them in our subcommittee. Stephen?
Yeah, I was just going to say in response to Ira, contingency fee of what? In criminal and family law, they're prohibited. Name change and gender change don't really lend themselves to it. Unlawful detainer doesn't really lend itself to a traditional contingency. The only thing that lends itself is enforcement of judgments in employment cases, and wage and hour cases are out of the program, at least tentatively, except for enforcement of Berman judgments in limited jurisdiction. So there is, as I understand it, the exception for enforcement of judgments. My personal view is if the standard contingency fee is a third, we should be picking a number less than that as a lower cost alternative for the client. I'd be fine at 25%. I'd be fine at 20%. It doesn't really matter to me, but I agree with the recommendation, no contingency fees except enforcement of judgments. And I think there should be a cap. Thank you.
Okay, let's hear briefly from Ira, then Carolyn, and then we'll need to move on.
We also have we're allowing paraprofessionals to work in any administrative proceeding that non-lawyers can work in, and a lot of those involve money that could be recovered. And also, maybe I'm not remembering this right, but in employment, aren't we allowing wage and hour in the limited jurisdiction, up to the limited jurisdiction court?
No, we are not.
All right, then I'm not remembering it right. But we are allowing it in the labor commissioner proceedings, and those can be a lot of money.
Yeah, and if I could suggest, if any of the practice area subcommittees have feelings about this, and we might be circling back after the fee cap or fee regulation discussion, but if there are practice areas that we didn't catch with the enforcement of judgment rationale that should potentially be allowing contingency fees, like administrative law issues, we would love to hear it. So.
Yeah, that is a good point. Yeah, any subgroup who thinks, my subject matter area really should allow for contingency fees, let this group know that. Ira, I presume your hand is still up from before, and Stephen Fleischman, ditto?
Well, we are allowing enforcement of judgments in wage and hour.
Right.
In court. All right.
Correct. So that would be where we are recommending contingency fees be allowed.
Okay. I don't see any other hands. All right, so folks, obviously anyone who wants to participate in the upcoming subgroup meeting is more than welcome to do so. Anyone who wants to send in comments is more than welcome to do so. I would like to extend a lot of thanks to Amos and to Fariba and to Greg, because while I know it was slightly shocking to get such a large memorandum and hit your inbox on Wednesday, think about what it took to actually prepare that memorandum. So it's been a massive amount of work with a massive amount of thought. And I just want to extend my thanks personally and on behalf of the committee for all the work and for continuing to do that. So we're going to move into, let's do one that will hopefully be shorter. Let's start with health and general civil, please. And then we'll move into employment since we lose Judge Yu at 3 o'clock. Ira, you had your hand up?
Yes, I'm reading part of the recommendations of the employment subcommittee in the last bullet point. Paraprofessionals.
So we're going to get to Ira, we're going to get to the employment subcommittee group and have a discussion about substance. So if you could hold your question, unless it's something that needs to be addressed right now.
Well, I think so, because Steve said, and maybe I'm still wrong, but Steve said that we're not authorizing wage and hour cases.
Okay,
Limited
I'm
jurisdiction
gonna,
court, it says we are.
okay, hold, because we're actually going to be discussing the recommendations after this group. So I don't think it makes sense to discuss part of it right now and then in 15 minutes discuss it again. So let's hold that and let's make sure we're clear on what the recommendation is when we get to the employment group. Okay, who is leading the discussion on health?
Linda, had you discussed this with Dana or?
No, but I'm happy to. I chaired the health subcommittee. We had a very active group. And in the interest of time, I will be very brief. The areas identified in the Justice Gap study were being billed incorrectly for medical services, having health insurance that would not cover medically needed procedures, and not being informed about financial assistance for healthcare or free care. We interviewed many experts in this area, and the committee concluded that you do not have to be a lawyer to provide help for the first two areas. And we felt that we didn't want to then offer up an educational requirement and a license in an area that doesn't require a JD now, that it could be confusing and interrupt services that seem to be working. We also learned that there are health consumer alliances all over the state of California that provide these services free of charge without income limitations. And that we would want to recommend that the state bar help drive consumers to those alliances where they can get this kind of help for free. We did learn from all the interviewing that we did that we believe the area of medical debt defense could use some assistance from a paraprofessional, and we have asked the Consumer Debt Committee to take that issue on. Are there any questions about our recommendations?
Okay, do we want to?
Do we have it written up?
Linda, is there a motion for this, a resolution for this one?
Yes. So give me a moment to read through this, please. What does HCA stand for?
That's the Health Consumer Alliance.
Okay, I'd recommend that we actually write that out rather than using an acronym. Okay, does anyone wish to be, oh, here, I've got some hands. Julianne?
Yes, thank you. I would also like to point out that there are two huge state agencies, the Department of Managed Healthcare, which regulates managed care companies, and also the Department of Insurance, which regulates a sliver of the remaining part of health insurance that is regulated by the Insurance Commissioner. Both of these agencies have what are called ombudsperson offices, and they also provide free advice and assistance to holders of managed care policies and or insurance policies. So when you're talking about these HCAs, it should also be pointed out that there are two state agencies that provide.
So Julianne, if you could
Yes.
please, because what I'm hearing is, and I'm going to ask you to say it again. What I'm hearing, first of all, whose motion is this? Is this Dana's motion?
This is the motion from the health subcommittee.
Okay, but we need a person to actually say it's my motion. So Dana, is this your motion?
It is.
All right, and would you accept a friendly amendment from Julianne to expand where it says recommending that the state bar assist in publicizing the availability of health consumer alliances? Would you accept a friendly amendment to include the other entities that Julianne was identifying that can provide assistance to people in these circumstances?
Yes.
Great.
So Julianne, give me 1 second to read this. I'm not sure that the legislative efforts of those programs is going to make sense in regards to all of it, but let's get down what the agencies are and then talk about how best to write this.
Sure. And I believe it's called the Department of Managed Healthcare, DMHC. Thank you.
So it currently says Health Consumer Alliances, the Department of Managed Healthcare, and the Department of Insurance, including supporting the legislative efforts of those programs. I'm not sure if the programs do we need to say legislative? Could we just say including supporting the efforts of those programs to require that availability?
I don't know that the two state agencies are actually
Right.
working on that.
So I guess part of my question is, do we need this last phrase in here?
That was going to be my question.
I don't think we need it.
Julie, we could put it in the minutes. Oh, you don't think we need that phrasing? I just didn't know if we needed the fact that there are two state agencies to be added to the resolution.
I personally would prefer it, just to make it clear that we do want to recommend that the state bar publicize the various means by which people can get assistance, I would think, but you can correct me if I'm wrong.
Perhaps we could just have a separate sentence that talks about the efforts made, because it was one of the things that we heard loud and clear from the HCAs. They need help informing consumers that they are out there.
Exactly. So you could